Oh, she can't make it either.
Oh, well, I did sort of skim through it. I'm aware of what we're going to be talking about. I don't usually read every single page anyway. Oh, yeah.
Oh, yeah? Yeah.
Right.
Zombie City. Wow. That's a lot.
Thing that gets you is the roundabouts.
I hate roundabouts.
That's just because you're not European.
Yeah, I just don't.
They're all over Europe.
Counted them, but first time I saw one was in New Jersey, and I didn't know what to do.
They have them. I have quite a few of them in Berkeley.
Oh, really? That explains a lot. I come from out there.
Good afternoon and welcome. This is the regular meeting of the Sunshine Ordinance Task Force, called for Tuesday, August 25th, 2009 at 4 p.m. and beginning at 4 p.m. Roll call, please.
Member Craven Green.
Here.
Member Craven Green present. Member Nee.
Here.
Member Nee present. Member Cotton. Here. Member Cotton present. Member Washburn.
Here.
Member Washburn present. Member Caneva.
Here.
Member Caneva present. Member Johnson.
Here.
Member Johnson present. Member Chu. Member Chu excused. Member Chan. Member Chan excused. Member Goldman.
Here.
Member Goldman present. Member Williams. Here. Member Williams present. Mr. Chair, we have a quorum.
Thank you. Are there any changes to the agenda?
Mr. Chair, item number 15 and 16 have been withdrawn.
Okay. We have had a request for a change from one of the respondents to a matter that's to come before us. I don't see the complainant here, however. So what I think is a good idea, and then this is for items 19 and 20, Peter Warfield versus the Library Commission. Is Mr. Warfield here? I didn't see him, and I don't see him now. Okay, so what we will do then is proceed with the agenda as normal, and when Mr. Warfield comes in, we will handle that as soon as we can. We do have a long agenda tonight, so for obvious reasons, we want to move as expeditiously as possible, but I will schedule a couple of brief recesses, one at 6 p.m. or shortly thereafter, and one a couple of hours after that. And with that, would you please call the first item, Mr. Clerk?
Item number 1 is the approval of minutes for July 28, 2009.
Okay, do I hear a motion on the minutes?
Members, I just had some minor typos and whatnot that I gave to Chris to clean up, but I move that we approve the minutes as amended.
Is there a second?
And second.
Okay, moved in several seconds. Is there public comment on the minutes? Seeing none, public comment is closed. Discussion? Roll call, please.
On the motion to approve the minutes, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cotton. Aye. Member Cotton, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Aye. Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Mr. Chair, we have 8 ayes.
Thank you. Item number 2, I think we can skip over unless anybody on the committee, on the task force, or in the audience wants to make any comment. Ms. Allison has moved back to the East Coast. She's not here to receive her citation. so we can dispatch with this perhaps very quickly. Is there anybody on the committee on the task force who wants to make a comment on Ms. Allison? Okay, is there public comment on item 2? Okay, seeing none, then we will send a certificate of appreciation to Ms. Allison at her new address, and we move forward to item 3. Mr. Clerk?
Item number 3 is the hearing on the status of the January 6, 2009 order of determination of anonymous against the San Francisco Police Department.
Okay, is the complainant here? Okay, please approach the microphone. Thank you for coming. You have 5 minutes.
My name is Ray Hartz, and obviously I'm not anonymous anymore. I had some interesting, yesterday I went to the City and County of San Francisco Index of Records and again checked to see if there was anything listed for the San Francisco Police Department and or the Police Commission, and again there is still nothing. There are no persons to contact, no telephone number, and certainly there is no listing of the documents or public records that the San Francisco Police Department or Police Commission hold in their area of responsibility. I also did a trip last week to 2 district police offices in 850 Bryant attempting to get a copy of a police procedure, which I already had a copy of. So I knew the name of the procedure, I knew the procedure number, and I spoke to 14 people, all of whose names I have, none of which who would agree to either give me that copy of that procedure or even reply that it existed. So I would say that it is still a very, very plain issue that the San Francisco Police Department and its officers do not feel any compulsion at all to respond to requests for public documents. This was a standard police procedure relating to how officers are supposed to handle traffic incidents. I had received it 2 years ago when this whole process started for me in July of 2007. And at that time, I went around and around and around having officers hang up on me, swear at me, and direct me to people who then proceeded to ask me, why did you call me? All of the officers went through a process of asking me why I wanted what it was. If I made any attempt to tell them what it was, they simply either hung up on me or swore at me. So basically what we have is we have a police department that feels that if a citizen decides they want to look into how something is handled, including looking at the procedures the police department is supposed to follow, they are not entitled to do so. And they feel no hesitancy at all to be abusive to those requesting the documents. I went to 850 Bryant. I saw 8 people, all of whom said, I don't know what you're talking about. What I did is I asked for the procedure by name. They said, I don't know what that is. I gave them the procedure number. They said, I don't know what this is. I don't know who should have this. And they simply sent me from person to person to person. Now, we have been going through this for over a year. It was over a year ago that I filed my original complaints on both of these, the police department and the police commission. And I would think between then and now, especially since orders of determination for this particular issue was issued in January of this year, they would have made some effort to do something. But nothing has been done, and it is obvious from my experience that they don't intend to work with officers to let them know that if a member of the public approaches them with a request for something which is a public document, how they should handle that. So I really don't see any sign on this side that this letter of determination has made any impact at all. Now, I've raised this issue before. It has been 10 years since this law passed. And in that entire period of time, both the commission and the police department, in this particular case, the police department, has been aware of the fact that they are supposed to keep the index of public records updated, and that they are supposed to work with the public to give them answers to questions they have relating to public documents. They haven't done it so far, and even with a letter of determination staring them in the face, they still seem to refuse to do so. Now, when Lieutenant Riley was here the last time we discussed this matter, he was asked, I believe, by Member Nee, as to some issues about when this was going to be, and was the new police chief going to be an issue, and some other things, and he was very testy and said, I'll answer the question, which he then proceeded not to do. So I'll be honest with you, I fully expect that today they will have made no further progress and really will have made no further attempt to work with officers to get them to understand the Sunshine Ordinance or to themselves comply with it.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent here? Thank you for coming. You have 5 minutes.
Good afternoon. I was wondering if there's a possibility of consolidating this with number 4 because the answers are the same. and it's the
Different
same
complaints.
issue. Okay. Then we'll pick up and say the same thing then, I guess, because I'm here to represent number 4 as well. As I said last time...
Identify yourself, please.
Oh, I'm sorry. Lieutenant Daniel Mahoney, head of the Legal Division, San Francisco Police Department.
Thank you.
As I stated last time under public comment, the index of records has been completed. It was forwarded to the city attorney. The city attorney only recently, as of yesterday, sent it back to me in the completed state in the template that the city administrator wanted it. And late last night, I forwarded it to the city administrator for inclusion on the website. So from as far as what we can do from the police department, the index of records is completed.
Okay.
Okay?
Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Okay. I have a couple of questions. Mr. Hartz, please approach the microphone. And I'm sorry to make you chew your cabbage twice here, but
Sure.
What was it you said you requested and were met with abusive treatment?
It was a police procedure that tells police officers in the city of San Francisco what they are required to do in the event of an automobile accident. In other words, what they're supposed to investigate, what law they're supposed to follow. A lot of it has to do with the San Francisco Vehicle Code. And I wanted to do two things. One, I wanted to see if there was any effort now, because 2 years ago when I tried to get this, I went around and around and around and went through a lot of abuse before I actually brought it to this committee. And this time I wanted to see, number one, whether I would go through the same abuse, which I did. And also I wanted to see if there were any changes to the procedure over a 2-year period, which I thought was a very reasonable.
Okay, and there was
question.
some kind of a number attached to that? What did
Right.
it-
It's a police. It says San Francisco Police Department Ordinance number, or no, it says procedure number, and then it gives a procedure number. I don't have that with me, but I have.
not a problem.
Basically, this time I didn't do what I did last time. I got everybody's name first before I told them what I wanted, because the way it worked the first time was once they started asking me why I wanted it, if I wouldn't tell them, they would hang up. Or if I simply said, I'm not really required to tell you, or if I simply said, it's something I'm just looking into for I even tried to make up excuses like I'm doing a paper for a class I'm doing, and I just wanted to see this procedure to see what it says.
Okay.
But in any case, the answer always seemed to be the same. Either direct me to someone who would ask me, why are you calling me, or simply hang up.
All right, thank you. Lieutenant Mahoney, please. In light of what you've told us, how soon can we expect the index of records to be up on the web?
Couldn't answer that. It's in the hands of the city administrator. I emailed it late last night. I sent a follow-up email this morning, and I can certainly give them a call tomorrow just to make sure they got the email and get a timeline for that. But now it's in their hands. What I was told was that the first time we tried to send it, city administrator wouldn't accept it because it wasn't in the proper format in their template. The city attorney has assured me, because she just did this with the DA's office, that it is in an acceptable template and acceptable format. So I don't see any reason why they wouldn't take it now.
Okay. Thank you. Is there any kind of a motion, any kind of referral that anyone thinks is necessary? Member Williams.
Question.
Speak into the microphone, please.
I have a question. Is it appropriate for us to be proceeding without a city attorney sitting here?
Well,
This is
there's
the
nothing.
first time in
There
all
is
these
nothing.
years I've never seen a city attorney sitting here.
There is nothing technically improper. We are, Mr. Rustum, I believe you told us Mr. Laurenti will be here?
That is what I was told.
He'll be here.
Okay. But there is nothing technically improper about it, particularly since we do have, under the ordinance, we have an attorney as one of our members who is perfectly capable of interpreting a lot of what comes before us in terms of how the law applies. Okay, I think there are really two things working here. Number one is the index of records. And number two, and I take this very seriously, is the way that Mr. Hartz has been treated when going after public record. Under the California Public Records Act and the Sunshine Ordinance, a custodian of a record, a person responding to a records request, is not permitted to ask why a requester wants a record. It's difficult to find an individual here in violation of the ordinance. However, it seems to me that the buck has to stop somewhere. What I would suggest at this point is to refer this matter to the Education, Outreach, and Training Committee and have that committee contact the Chief of Police and have the chief of police be informed of this grave violation that has been visited against Mr. Hartz, and have the chief of police acknowledge understanding of what the issue is and send the word out down among the troops as to what the law is on this. Member Craven Green.
I'm not, with respect, I'm not sure that I would not actually agree with that. We don't know the other side. This isn't the complaint. We haven't found facts. We haven't heard from the other side about what happened at all. We have one side of the story, and that's all we have. And so I just think that's totally inappropriate to have the chief respond to EOT to an issue which we haven't made an order in. There may be some substance there may be some problems there, but I don't think that's the appropriate due process way to handle this. In my view, there has been no finding on that. With respect to the issue of the index of records, it sounds like after much delay, and unfortunately after Mr. Hartz having to push on this issue, the police department and the police commission will now have an index of records shortly up for individuals to review in terms of helping them identify what records exist and how to get them. I would say that if there are continuing problems with that index of records, if Mr. Hartz feels like it doesn't comply with the requirements of the Sunshine Ordinance, which we can't tell because we don't have a copy of it yet, that issue be through the chair followed up with at the EOT, and that the EOT begin to look at the compliance, all city departments' compliance with the index of records more generally, because as I understand it, there are many, many departments there who haven't updated their index of records in the 8 years or 10 years that it's been since this was initially passed. So I think this is part of a broader thing that EOT should be pushing forward in terms of getting those indexes of records not only posted but up to date.
Okay. Thank you. Member Cawthon.
Yeah, I have a couple of comments. Lieutenant Mahoney was appointed to this position a few months ago, and he's been before the EOTC twice. I believe that he has been pushing. Now, I can't guarantee what form the index was sent in and whether or not it's going to conform to the police department and to the police department standards. But I will say that I think he has made a good effort. I think the effort before was conspicuous by its absence, so that's number one. And number two, at the EOTC, we are really thinking about a lot of things that need to be done. Regarding asking why you want something, there's one custodian of records who knows I'm a member of the Sunshine Task Force, and he asks me why I want things. So we have to maybe put on the agenda, Mr. Rustum, that we need to do more outreach regarding what 67.21 of the ordinance says about how a custodian of records should treat a records requester.
Thank you. Member Williams.
Member Chairperson Nee, as many times as Mr. Hartz has been here, I just find it despicable that we haven't closed this. And I also agree with Member Craven. The chief is so new. We're not going to get to him. This man is making his rounds, and he's new to the city, so he's had so much on his plate. I doubt if the letter even gets to him, to the new chief of police. But I am concerned about, it seems to appear to me that when we find a violation and it's not complied with, everything is being dumped on the EOT right now. Everything is coming through the EOT for outreach and training. Everybody in the city in this last 10 years know what this Sunshine Ordinance Task Force is and what it is supposed to do. They are blatant and just obviously don't take us for granted. And it's going to have to be some kind of way that we're going to have to make a stand in some kind of way because we're losing our credibility. Definitely. We're losing our credibility as a task force. And we make a commitment to people to serve them. It should be for a whole year. Mr. Haas has been here. And we can say that we like certain people and they can, but they're not coming up to par. They're not coming up to par. And we as a task force are letting them get away with it. And I really feel strongly about it.
Okay. While I agree with your sentiment, I think Member Craven Green made a very telling point, and that is we have not heard the other side of Mr. Hartz's complaint. And there would, I think, if we were to take any kind of action against the police department or send any kind of communication to the police department at this point, it really wouldn't be proper to do so. Is there any public? Member Johnson?
I just don't think that the matter has been fully resolved, and although Mr. Hartz has come and come again, if we can't get a straight answer on when it's going to be up and running, I move that we put this on next month's agenda and see if the index is up by then.
Okay. There's a motion to continue to our next meeting. Is there a second? Moved and seconded. Is there any public comment? No, sir. Seeing none, public comment is closed. Is there any further comment by the task force? Roll call, please. What?
On
Roll
the
call,
motion,
please.
Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon. Member Cawthon, aye. Member Washburn. Member Washburn, aye. Member Knebel.
Aye.
Member Knebel, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
No.
Member Williams, no. Member Chu. Member Chu excused. Member Nee.
Aye.
Mr. Chair, we have 7 ayes.
Motion passes. Lieutenant Mahoney, Mr. Hartz, thank you both very much for attending and for speaking to us today. And would you move to item 4, please?
Item number 4 is hearing on the status of the February 24, 2009 order of determination of anonymous against the San Francisco Police Commission.
Okay, Mr. Hartz, please approach the microphone. You have 5 minutes.
Members of the board, thank you. Contrary to what you may believe from my appearances before this board, my real intention here is one of those things where, God closed the door, he opens a window. When I first encountered this problem back in 2007, I really said, gee, I'm not really that dumb of a fellow, and I don't understand why I can't seem to make myself clear to all of these professionals about wanting something and explaining to them that it's a public record and why can't I have it. To get the same kind of response repeatedly from multiple officers really raises a question in my mind, simply because I also have read a 2003 report from the Office of Citizen Complaints to the Board of Supervisors relating to the fact that when officers are investigated relating to citizen complaints, they often show up at the investigator with a gun in hand, that investigators during the process had been threatened by the officer, and so forth. So I really, and one of the biggest things they said was, okay, there's a statute of limitations on any citizen complaint against the officers. And one of the requirements of the law is that before I can bring a civil suit against a police officer or the city of San Francisco's police department, I am required to go through a hearing process with OCC. Well, the interesting thing is 59% of the cases that go before OCC close within 1 year. Guess which 41% don't close within the year? All the ones that will fall outside the statute of limitations. And the process that I went through trying to simply find out, like I said, I was in the military for 12 years. And whenever there would be something wrong, the very first thing we would be required to do in investigating that would be to go to the policies and procedures that were established by the command or by the Navy, and we would look at those and say, what was it that this person was supposed to do? And that's what I was trying to do with this police directive. I felt the officer had handled himself badly, and I wanted to see the procedure to say, what does the police department tell an officer that they're supposed to do in the circumstance? And that's where this whole thing started, and it's been going on for 2 years. I went from there to the city attorney's office, where I was taken out in handcuffs because the response I got when I walked in said, I would like to speak to somebody about a problem with the police department was, and I wrote this down, I have it on a Post-it note at home in the book that I was reading at the time. Honey, we don't want to talk to you. We defend the police department. Get out. And I said, may I speak to a supervisor, please? And the answer I got was, get out. And what happened then was they called the sheriff. The sheriff came up, said, you need to leave. I tried to explain that I agreed. I said I would like to speak to a supervisor, and I'm willing to sit here and read my book, which is what I was doing when they walked in, until such time as someone might be able to come to me and either talk to me or make an appointment to talk to me.
Okay, Mr. Hart?
Yes.
Pardon the interruption, sir, but this has to do with your complaint against the police commission.
Correct.
And whether the police department has included and posted the commission's index of records.
Correct.
And, I would advise you to limit your comments to that issue.
Okay. Bottom line is, when you try to get something from them, it's almost impossible because they ask you for the name of the directive. They ask you for all the information about it that you really kind of have to see before you can ask them for it. It's the same with the police commission. I sent requests on the email, through the email on the website for the police commission asking for information relating to 2 issues. The answer I got back was, call the police department. When I said, these are records pertaining to the police commission, their answer was, call the police department. And that's where we went around and around in the circles. If a citizen of this city is going to have access to the public documents maintained by either the police department, and in this case the police commission, they have to have a way to start in the looking. They have to have an index, which is what the index of records is supposed to do, so they can go in there and say, this is the specific document I want, and that way there shouldn't be an issue about what it is. But in this particular case, what I'm saying is you can't even do that, even if you have the document. So I'm pleased that the lieutenant has said that there has been progress made and this will be posted, but I'll be honest with you, I'm at the point now where when I see it, I'll believe it. There is a police commission meeting tomorrow, and I appreciate the fact that the issues I had last week are not before you today. And I'm going to take them directly to the police commission tomorrow. I'm also going to iterate what the lieutenant has said today so that it is very clear to the commission and to the police chief, who I believe attends all those meetings, that this has been before you, that there have been determinations, and that the lieutenant has made a commitment to get those taken care of. I will also inform them of the individuals. Now, if I do decide to file complaints, I have the name of the 14 individual officers I spoke to during that process last week. And if I do decide to go forward with individual complaints, I will file 14 complaints against each of the individual officers. But in this particular case, the San Francisco Police Commission is responsible for making sure that it is in compliance with the law. They have so far failed to do so. And again, I hope that the lieutenant gets up and makes a commitment to them also meeting the requirement.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, respondent, please. And again, we would ask you to identify yourself.
Certainly. Good afternoon, Lieutenant Daniel Mahoney, Officer in Charge, Legal Division, San Francisco Police Department. The city attorney originally had advised us that the police commission is not a separate entity. They are under the police department as well. Although the city administrator's website does have a separate filing for the police commission. In the index of records that I've sent to the city administrator, the police commission records are included with that. So as the department's records get inputted up on the website, I'm assuming and hoping that the commission's will as well. They're in the same email.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Cawthon.
I had an idea, since we have continued the initial issue regarding the police commission, police department index. Why don't we simply add to that the police commission index, and we can take them both up next month?
Is that a motion?
Yes.
I will second that.
Okay, moved and seconded. Is there public comment on this matter? Seeing none, public comment is closed. At this time, we will give the respondent and then the complainant opportunities to present any wrap-up remarks or rebuttals. Okay, nothing from the respondent, Mr. Hartz? You have 3 minutes.
Thank you. Again, one of the things I've noticed in sitting through a lot of the meetings for the task force and its subcommittees is that many times people will come before you and really be flummoxed by the complexity of what they're expected to present in a 5-minute period. Sometimes when they have been engaging in a back and forth between the department, as I have between in this case, the police commission. It really becomes a difficult thing to go back and forth and cover something that's been going on for 2 years in a very brief period. But I really do feel that it is in the interest of not only the citizens of the city of San Francisco, but of the police commission in this case as well, to have a clear understanding that, number one, if a citizen comes to you and has concerns about the operation of your department and wants to look at policies or procedures or other things which clearly fall in the public domain, that they should not be thwarted in their efforts. It is the only way that the citizens become part of the government is if they're allowed to. And if they're barriers put up, if they're hampered in being able to look at things which they clearly know that they have a right to do by people who are supposed to uphold the law, it really sends a bad signal. You know, I think any city agency or any city department should be willing to sit down with a citizen of this city, and if they have questions about their operations, procedures, or policies or whatever, they should be able to deal with that. And I think in this particular case, it was really kind of sad to me that the police commission, who is the civilian oversight body that is supposed to ensure that the San Francisco Police Department follows the law, doesn't even follow it itself. Now, they can say, yes, we have designated the police department to keep those records for us or to maintain the index of records, but in this particular case, they didn't do it, and they have no out now. They can't say, well, we told them and they didn't do it, so it's not our fault. No. When you delegate to someone, you have a responsibility not to abdicate, but to delegate. Delegation is not abdication. Delegation does not mean I give it to you. Once I give it to you, I'm not responsible anymore. They are responsible for maintaining the public records index for the San Francisco Police Commission, and they are also responsible for seeing that the San Francisco Police Department maintains it as the civilian oversight board. And either way, the San Francisco Police Commission has failed to meet it. I'm glad that, again, that the lieutenant has indicated that that is happening. And basically what I'm going to be doing over the next few months is once that gets up, I am going to be going to the individual police stations and making requests for public documents. And every time I get a case where they don't give me what I'm asking for, I'll file another complaint. Because apparently it took this long to get the word to them.
Thank you, Mr. Hartz. Matter is back with the committee. There is a motion on the floor for continuance. Any discussion? Roll call, please.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu excused. Mr. Chair, there is 8 ayes.
Thank you. The motion carries. At this time, per the request of the respondent, we are going to take items 19 and 20 out of order. This is Peter Warfield versus the Library Commission. Mr. Warfield, I would invite you now to approach the microphone, please. Thank you for coming. You have 5 minutes.
Mr. Chair, I consider the taking of this out of order without any request from me or input from me a very great bias, and I would like, therefore, to withdraw this or postpone it until next month.
Okay,
I was
Mr.
not asked, and the idea that a respondent who has been found in violation repeatedly, namely the library and the commission, should get special treatment and special consideration, this body bending over backwards to provide that without even consulting or asking me or my opinion on the matter, I think is grossly unfair and inappropriate and doesn't speak well for the lack of bias of this body. And so I do not want to go forward with this at this time in this fashion.
Okay, Mr. Warfield, I did attempt to communicate with you early today. When I got the request from Ms. Gomez, I immediately sent you an email and left you a phone message. Did you get either one of them?
I received a phone message which had been sent 4 hours before this meeting, in which I was with temerity told that you would appreciate my arriving here on time because you had received a phone call from Ms. Gomez, and therefore, on her request, you would put this item up on the agenda much earlier than it was scheduled. There wasn't even an explanation as to why or what specific condition or circumstance made this action happen. Again, Ms. Gomez just last month was found in willful violation. The library has been a dozen odd times found in violation. You've even not found them in violation but complained that they haven't come on hearings when they should have. And to bend over backwards without even consulting whether I have an opinion on this and to just simply put this on the agenda is, I think, a gross unfairness. There are other issues with regard to the process that has brought us here today, which I would have separate comment on later.
Okay. Mr. Warfield, first of all, you have my phone number. If you had an objection, you could have called me. When the meeting started, I announced that we had received this request. I never promised anybody that I would move this forward. However, when I explained that Ms. Gomez has someplace she has to be not too long from now, I suggested moving her item up, I heard no objection.
I was not present, unfortunately. I came at 4:08 because of a Muni issue. I expected this item to be way, way, way late as item 19 and 20. And again, the message that I got on the telephone did not ask me. It simply asserted that this item would be moved up. And that in combination with some other issues. For example, there's a library letter in here that was received well after the procedures say anything is permitted to go in the agenda, and yet it is in this book here. My letter to you and to the administrator about a screw-up in the agenda that was damaging to my case, to the previous case, was not included, and no instruction was provided in this agenda that shows that error. So my comment about an erroneous a problem with the agenda is not included, but a late letter from the library is included. That's another example, I think, of bias. And as I said, I was not asked if I wanted to go forward with this early, nor was I invited to express an opinion on the phone message that I received.
Okay, point taken. Do you still wish to withdraw your complaint, or do you wish to proceed with it?
I wish to postpone it until the next meeting. And it's an option that I understand is open to folks basically on request.
Okay. Is there a motion to grant continuance here?
So moved.
Second.
Moved and seconded. At this point, we will call for public comment on the motion to continue. And if Ms. Gomez wishes to speak to the motion, we would be happy to hear from her.
When you asked for Mr. Warfield earlier in the evening, I thought to myself, well, it's not surprising he's not here. He's not until 19. He's way down on the list. He's probably not going to be heard until 8 or 9 o'clock anyway. So it didn't surprise me that he wasn't here. What did surprise me, rather, was when this was now brought forward, it was simply brought forward rather than saying, okay, the party's here, now can we bring this forward? Maybe if Mr. Warfield had been approached in that way, he might have simply said, well, okay, fine, if I'm being asked, I don't mind. But I can understand his perception that having just moved it forward without him having an opportunity, either calling someone, very honestly, with respect to the chair, I don't believe someone getting a message on the afternoon of the hearing could be expected to, number one, get the message necessarily, and number two, to simply say, well, I get to call members of the panel at home and have some sort of an ex parte discussion about the scheduling of the meeting. I really believe this should be handled in order unless both parties agree to the change.
Good afternoon, Sue Blackman, Library Commission Secretary and Custodian of Records. I would like to say that Commissioner Gomez, the chair of the president of the Library Commission, is present today. She came specifically, obviously, for this item. She does have to leave at 5:15. She has a board meeting of her employment that she has to attend, so we respectfully request that this item be heard. There is no time certain on your agendas for when items are heard. And as at the Library Commission, if we start at 4:30 and we have an item later and someone requests that it become earlier, if it's not a time certain item, it can be held any time during the course of the meeting. So my belief is it's up to the task force to make that decision, and if you would like to hear from President Gomez, she is available.
Okay.
Didn't mean to cause a brouhaha. I actually have to go to my office for a board meeting, which happens at exactly the same time.
You are Ms. Gomez?
I'm Jewel Gomez, the
Thank
president
you.
of the commission, sorry. Happens at exactly the same time every time, so, which is one of the reasons I wasn't here the reason I wasn't here the last time. So delaying it is just going to create the same difficulty. I understand that the secretary at the commission did attempt to reach the task force to have this item agendized earlier on the schedule so that I would be able to attend, since we know this is the regular time that I have to go to my board meeting. I have no problem with having it delayed. I don't know when your next date is, but I'm certainly make every effort to be here. If Mr. Warfield doesn't feel prepared to go forward right now because it's a couple of hours earlier than he planned, I have no problem with that. Thank you for attempting to accommodate my ability to speak to you directly.
Okay. The whole thing is regrettable that it's worked out the way it has. The next meeting for the information of all present is Tuesday, September 22nd. Is there a motion to continue?
You have that.
We have a second.
Okay, and we have a second. Okay, further discussion among committee, among the task force? Request for continue. Okay, roll call please on continue.
On motion to continue, Member Craven Green. Aye. Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Corcoran.
Aye.
Member Corcoran, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
And Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu excused. Mr. Chair, we have 8 ayes.
Thank you. Items 19 and 20 are continued until September 22nd. Okay, Mr. Clerk, could you call the next item, please?
The next item is item number 20, which is the
For items 5 and 6, I believe.
Item number 5 is the determination of jurisdiction on the complaint filed by Kenneth Kinnard against the Human Rights Commission for allegedly withholding information.
Okay.
Members, I move that we find jurisdiction on this item.
Moved and seconded. Is there any discussion? Is there any public comment on whether this matter has jurisdiction? This is not on the merits of the case, jurisdiction only. Seeing none, public comment is closed. Discussion? Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu, excused. Member Nee.
Aye.
Mr. Chair, we have 8 ayes.
Thank you. Okay, we are now ready to hear the merits of the case. Is the complainant present? Mr. Kinnard? Mr. Rustum?
Mr. Kinnard was informed that the meeting would take place, but he did not respond.
Okay. Then I think it would be appropriate for us to proceed. Is there anybody here to present facts and evidence in support of the complainant? Okay, I'll tell you what. Is the respondent here?
Yes.
Okay, would there be any problem with putting this back to later in this meeting, not continuing, but putting it back to later in this meeting for when Mr. Kinnard is here?
Today,
Yes.
Well, first of all, my name is Melinda Canios. I'm the manager of the certification unit at the Human Rights Commission, and I will not be available later.
Okay, what time do you have to leave?
I have to leave actually at 5 o'clock, childcare.
Oh. All right. What is the feeling of the task force here? Should we? I am inclined to go ahead with this.
Mr.
Member
question.
Knebber?
Yeah, I agree. I mean, we're 45 minutes into the meeting. I think we have enough allowance for people showing up a little bit late. I would be inclined to go ahead with it as well.
Member Cawthon?
Have we heard, Mr. Rustum, have we heard from Mr. Kinnard? Did he
Through
say
the chair,
he was
no, we
going to
haven't.
come? You didn't hear from him at all? Okay.
Okay. We will proceed then, and since you're already at the microphone, please introduce yourself, and you have 5 minutes.
My name is Melinda Canios. I'm the certification unit manager at the Human Rights Commission, and I don't have a case.
Okay. Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, committee? Member Craven Green?
Yes, Ms. Canios? Did your office receive the March 4th, 2009 IDR request?
Yes,
And when did you respond to that?
in April 2009.
Why did it take so long to respond? It's an IDR for a certain set of documents.
Because he wasn't very clear on what he was his request, so I asked him to make that clear, and he did, and then I responded.
What was the ambiguity? I mean, the documents that we have don't really explain much of it. So, because the documents that we have are the complaint, which says he requests copies of the certification application number 47101 West Bay Trucking. Was that the original request?
I'd have to look to be reminded, but the information we did have, we did provide to him.
Right, but I'm just getting a sense of why it took so long. And so, I mean, because IDRs generally have to be responded to by the close of the next business day, unless, for example, the documents require collating or gathering, their substantial nature or number.
Mm-hmm.
How many documents are we talking about?
Well, the application itself is a 3-page document, and then there's additional documents that are included with that application, including tax information, personal tax information, and tax information for the business, lease, and contracts. So it could range from 20-page to 100-page document. It depends on the size of the business and the employees and that. So and the information that we had, we gave to him. We did provide to him.
Okay. So the delay then, from your perspective, was because of ambiguity in the request, but once you were certain of what he was requesting, you responded within
Yes.
a matter of days? How long did it take you to respond?
A matter of days, I believe.
And again, you produced the documents on April when?
I believe it was April 6, 2009. We'll have to look. If you'd like it, let me get the file.
Sure.
April 7th.
April 7th. Thank you for the clarification.
Yes.
Mr. Kennard, in his correspondence to us, indicated that HRC finally responded on 6/25/2009. The response was a one-page vendor sheet. Was there something that you provided to him supplemental with respect to this request that came in on June 29th?
No, what I have is a copy of what I sent to him on April 7th, 2009. I don't recall sending anything later to him.
How much information did you provide on April 7th?
It was the data log sheet.
What's the data log sheet?
It is the sheet that is generated from their database, and it's the contact information on the business.
Is there any other documents? I mean, that doesn't seem to me, based on your prior answer, to be the complete application.
Correct. We did not have the application. We are not required to generate information, only to provide that information we have.
Right. So what happened? The application was destroyed. You don't have it?
It's in storage.
And did you proceed to retrieve it from storage?
This application was the first time this business was certified was well before 2000, so that application was not in our records.
That means that application is not in storage?
They have subsequent ones, and those are in storage, but the one he requested, we did not have at our site. It's in storage.
I'm sorry. So the one that he requested, meaning the one 47101, is that how you identify it?
No, I don't know what that is, 47101.
That doesn't ring any bells for you? That's how he identified it in his request. Application number 47101, West Bay Trucking.
No, that's not. I have no recollection of that.
You don't use a number similar to that for tracking these applications?
No.
All right. So when you said there was one that he requested, what one did he request?
The only one that he requested, the application he requested. I don't know what the number is referring to.
Okay, but what application did he request that you didn't have? That's what I'm trying to figure out. Sounds like there's a bunch of applications. They've probably been recertified, I would imagine, over the course of a number of years. Would that be correct?
Probably. I cannot say for sure.
Sure, but that's kind of the way it generally goes with businesses who get repeated certifications.
Mm-hmm.
Okay, and so you're saying that you understood that Mr. Kennard asked for one specific certification. Is that correct? Okay.
We don't have their application. What we did have was their data log sheet in our database, from our database.
And that application is no longer in the possession of the City and County of San Francisco, or is it in storage?
It's in storage.
Okay. Are you aware that under the Sunshine Ordinance, if someone asks you for a document and it's off-site in storage, that you're required to get that document from storage and produce it?
Yes.
Okay, and has that been done in this case?
No, we have not produced an application for him.
Why?
Because it was in storage, and at the time, I had given him what we did have on that particular business.
Okay, you seem to be missing the point. If I ask you for a document, and you say, well, you know what, we have this one page in our files here, but the rest of the information about this business is in storage, under the ordinance, and under, indeed, state law, you're required to go to the storage and pull that information for the requester. And it seems that that has not been done. And that's a violation of the ordinance and of the state law. Do you understand that?
I do understand.
Okay. Do you have any plans to comply with the law by going to storage and getting a copy of this information?
We can request it, yes.
Okay. And how long does that take? I know it takes some time.
Yeah, it takes approximately 3 weeks.
3 weeks to get it from storage?
Correct.
Okay. I don't have any other questions.
Okay.
Member Cawthon?
I do. I just wanted to mention that when you get an immediate, I'm hoping that you realize, as Ms. Craven Green said, that when you get an immediate disclosure request, the law requires that you respond by the end of the next business day.
Mm-hmm.
It doesn't say you have to produce the documents if you don't have them, but you do have to respond to the person.
Mm-hmm.
The law also permits you to take a 14-day extension, and I'm not sure if that's calendar days or business days. You can take a 14-day extension if the documents are hard to come by, i.e. if they are in a warehouse. But it seems to me that anyone should be able to retrieve documents from a warehouse within 2 weeks. So that is another part of the law that the Sunshine Ordinance requires compliance with. So I'm just hoping that you understand these issues. Yes. And if you don't, I chair the Education and Outreach Committee, and we're always happy to come and explain portions of the Sunshine Ordinance to people, or all of it, indeed, if that's necessary. Thank you.
Thank you.
You may be seated. Thank you. Okay. Have we asked for facts and evidence in support of the respondent? Is there anybody here present facts and evidence in support of the respondent? I believe we have, because I put the matter with the committee. That's correct. Is there any further from the committee? Okay. Is there public comment on this matter?
Ray Hartz. Having been through this procedure a number of times myself and had the city not show up, it seemed automatic that the board would then simply defer it till the next meeting to give the city time to show up. And I'm kind of surprised that it doesn't work both ways, that if for whatever reason the complainant can't show up, that it isn't automatically continued until the next meeting, rather than what has been done, which is hold a meeting where none of us is really clear what the heck's going on, because I don't really know what Mr. Kennard got, what he requested, and whether, I mean, it seems like the respondent has admitted that they haven't given him what he requested, and they certainly didn't meet the time frame. So, and now they're saying it's going to take another 3 weeks. So I think on Mr. Kennard's behalf, I think it's kind of unfair to have this hearing without him being able to present his case. And like I said, in my experience and watching all of the cases, whenever the city doesn't send one, it automatically seems to get continued. And I don't know why, in this case, when the complainant is held up, it isn't handled the same way.
Thank you. Is there further public comment? Seeing none, public comment is closed. At this time, the respondent will have any concluding remarks she would like to make. Okay, seeing none, matter is back with the committee. Member Craven Green.
I would move to find a violation of 6721 for failure to produce documents in a timely fashion, and a violation of 6725 for failure to respond to the immediate disclosure request. And through the chair, I would move this to be heard by the Compliance and Amendments Committee to discuss with Ms. I forgot her name, from the Human Rights Commission, the representative, about the status of retrieval of those documents from storage.
Second.
Moved and seconded. Discussion. Seeing none, roll call, please.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excuse. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu, excuse. Member Nee.
Aye.
Member Nee, aye. Member Chu. Mr. Chair, we have 8 ayes.
Thank you. It is now 5 o'clock. This is the time set aside for public comment on items not appearing on today's agenda. This on the agenda, this is
Item 31.
item number 31. We're going to take that now. Is there anybody here who wishes to speak to us on a matter not on today's agenda?
Ray Hartson, this is a matter I've raised before, and it goes back to the two items that we talked about before, but it goes more to the procedure of this task force. This last one was just referred to the compliance committee, and I have asked multiple times, both in writing and verbally, why the two complaints I filed were sent to education and outreach when your own instructions at the time those determinations were issued clearly indicated, both on your website and in your rules, that they should be referred to the compliance committee. And I'm kind of wondering why my complaints seem to get handled differently than your procedures stated they should be. I've gotten several kind of semi-responses. That's the way we decided to do it. But I really do have to agree with Mr. Warfield in that there are some things that are handled by this board in a way that they are very opaque, and when someone raises a question as to why they're handled that way, you can't get an answer. Communication is only effective if it's two-way, and two-way communication means I ask something and you answer it, or you ask something and I answer it. Now, you have the latitude to ask me anything you want, and there's an expectation that I answer it. However, none of us in the public are allowed to ask you anything, and we're certainly not entitled to any sort of a response. And again, my question is, when things are handled one way with one person and some different way with another person, without any sort of an explanation as to why, it does really give the perception that something is going on that is being hidden from the public. And as a board that is supposed to do all of its business in public, I think that is a bad habit to get into.
Thank you. Is there further public comment on non-agenda items? General public comment.
Yes, Peter Warfield, Library Users Association. This body, unfortunately, has had a history going far back with respect to its procedures and its lack of, at times, following its own procedures. There have been instances where the administrator, and I'm speaking of a prior administrator, went and solicited from the department late responses, and in a range of ways this body has at times not followed its own procedures. With respect to today's agenda itself and not any of the items in it, I was contacted by the administrator with respect to would I consider postponing my complaints. And it turned out from further discussion, though it hadn't been said at the beginning, that the administrator had failed to notify the departments promptly upon receiving my complaints, which were prompt. They were sent at 2:30 approximately on the afternoon that they were finally due for this meeting. Consequently, there was a time problem with respect to allowing the departments their 5 days to respond. And I was to bear the burden. I was asked to bear that burden by putting off for a month the hearings which people come to you for and which I have come to you for to get a prompt adjudication on. The procedures as I recall them, I don't recollect getting any procedures freshly. They have changed on occasion. Your own procedures are very clear in my recollection as to the deadline when material may be submitted for inclusion in the agenda. And yet, as I said, here in this book is a letter from the library that I believe came after even the deadline that was changed so that the departments would have 5 days. And now they have sent a late submission, which I understood would be in the room, but certainly not as part of the agenda, basically countering my complaint. And yet my communication to the administrator and the chair about a deadly problem with filing my exhibits is nowhere to be found. And I had requested that there be, and I was told that the body had been alerted that there was a problem. When I requested to see a copy of what had been communicated to the folks, which I think is only professional since it affects my case and whether or not you have been aware of problems with the evidence, I was sent a copy which, frankly, I couldn't understand the meaning of it. It didn't clearly say there was a mistake made. 17 and 18 should have had both of the documents that you gave, not just one in 17 and 18 and the other one in 19 and 20 where it makes no sense. And it is damaging to the case because basically those two documents are part of the one complaint. And that's a very big disappointment, and I hope that the task force will follow carefully its own procedures for the sake of fairness. Thanks very much.
Thank you. Is there further public comment on non-agenda items?
Yes, thank you very much. I have the impression that public comment began before 5 o'clock. Stop the corporate rape of the public library. Don't give money to the Friends and Foundation. Don't accept money from the Friends and Foundation. Sometimes 3 minutes is only time to say half what you want to say, and this is the other part that I started from last month. You will be happy to learn that the library commissioners have ostentatiously started reading a book while the public is talking. Apparently they consider this sufficiently insulting without having to muster the energy of laughing at us while we were talking. What they have not told you is that they have another device to show their contempt for public comment, and that is called the Public Comment Fund. And every time they hear something that detracts from privatization and their own special interests, they put $5 into this fund. The avowed purpose of this fund is so that the public, when they talk, will be considered as, quote, just raising money for the Friends, unquote. The Public Comment Fund raises money for the Friends and Foundation, and not only does the president of the Library Commission contribute to it, but there is no question but that she is the president because she contributes to it. It is of the essence that the cruelty and disdain that they feel for alternative opinions and non-conforming facts is a profit center. The final refuge of the grifters is that their lies rest behind a bulwark of, quote, positive, unquote, when in fact the only meaning of the term positive is self-serving. When you create a mechanism to control what facts are recognized and what opinions are legitimate enough to be expressed, you have to recognize the corollary, which is that eventually the mechanism of control will fall into the hands of moneyed interests. When that happens, democracy is lost because democracy will never create a profit center for everything. In fact, we are all disenfranchised in the face of money because finally they are taxing us to pay for our slave masters. If moneyed interests are given this power, only moneyed interests become legitimate. If you don't have the power to learn the truth, you don't know to what extent you're being lied to. And if you don't know what extent you're being lied to, your disenfranchisement is absolute. A lie can cover anything. A lie is a bottomless pit. If you have disdain for those who attempt to cross the barriers to the truth because those barriers are concealed as class barriers or social barriers that benefit you, then that disdain is disdain for yourself when you are the victims of the lie and need to redeem the truth. The victim of the psychic assault is just not that immediate victim. The real victims are those who suffer the distortion of the truth and the disenfranchisement of their interests, and that means all of us. Thank you very much.
Thank you, sir. Is there further public comment on non-agenda items? Seeing none, public comment is closed. Mr. Clerk, could you call the next item, please?
Item number 7 is the determination of jurisdiction of the complaint filed by Dave Snyder against the Clerk of the Board and Supervisor Chris Daly for allegedly denying public comment at a public meeting.
Thank you. Is Mr. Snyder present?
Members, I move that we find jurisdiction on this item.
Moved and seconded. Is there public comment on jurisdiction only? Seeing none, public comment is closed. Is there discussion on the motion? Seeing none, roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Emily, aye. Mr. Chair, we have 8 ayes.
Thank you. We're ready now to hear the merits of the case. Mr. Schneider, please approach the microphone. Thank you for coming, sir. You have 5 minutes.
Thank you, members of the task force. Let me start off with what happened on July 7th at the beginning of the Rules Committee. And that is, at that point, the presiding chair indicated that he was withdrawing his proposed charter amendment, which had been duly calendared as item number 7 on July 2nd, and that there would be, he announced at that time, there would be no public testimony allowed. You can certainly go to SFG TV for their for the video. A little later on in the meeting, it came up again, and the chair indicated, by the way, I kind of like the chair, personally. I looked up his record in Wikipedia. I'm pretty impressed, but anybody can make a mistake. And so later on in the meeting, towards the end, there were a whole bunch of people waiting to testify, and he said, I'm sorry, I told you before, this item has been removed. There'll be no testimony. And I'm a cab driver, among other things. I'm also a lawyer by background and a reporter. And one of the members of the public at that point turned around and said, well, I've never seen anything like this in my whole life. This is, and I went, yeah, it's not good. It's not good. The truth is, as far as I'm concerned, the truth is I'm bringing it to you to let you look into it. I'd like to make a few comments on the Yogi Berra aspect of it. If you had to make the wrong mistake, allow the free speech. There were a couple of things that could have been done. If the supervisor didn't like it, he could have allowed the testimony. He might have then, at that point, put it to a vote, and it wouldn't have passed, perhaps, if he had enough support on the committee. But he didn't even allow public comment. And it seems to me the public should have been allowed to comment for 2 reasons. Number one, on the substance of the merit of the particular item itself. And number 2, on the merits of withdrawing it. And they were not allowed either. It was a little rough shot. I'll leave it go at that.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is there somebody here from the respondent?
Good afternoon, Commissioners. My name is Linda Wong, and I'm the Rules Committee Clerk, and I'm here today with Rick Caldera, Legislative Deputy Director, to speak on the complaint filed by Mr. David Schneider. I would like to read for the record a response from Angela Calvillo, the Clerk of the Board, dated July 22nd, 2009. This is a response to complaint number 090355 filed by David Schneider against the Board of Supervisors and the Clerk's Office. At the start of the Rules Committee meeting of July 2nd, 2009, the Chair announced that agenda item number 7, which he is the sponsor of, was deemed inactive. The committee members did not object to the Chair's decision of not calling the item or taking public comment, and the withdrawn letter was distributed to the audience members. The Board of Supervisors Rules of Order Section 5.36 states, if the supervisor is sponsoring a measure or request for a hearing and the chair to which it has been assigned inform the clerk of the board they deem the matter to be inactive, the clerk of the board shall file the matter. Such matter may be reactivated as provided in these rules. Based on the Rules of Order section referenced above, we believe the item was filed accordingly. This completes the response from the clerk's office, and we're here to answer questions you may have for us.
Thank you. Sir? Okay, is there anybody here to present facts and evidence in support of the respondent? Seeing none, task force? Member Kneber?
I have a question for Mr. Laurenti. Is there any rules about withdrawn items and having to have public comment on them?
In terms of the ordinances or the Brown Act, I don't think there's anything specifically set out. I know that it's very clear in the ordinance that if there's an agenda item, that there has to be public comment before the item is acted upon. The question is, if the action is to take the matter off, if you could interpret the matter, if the matter is to take the matter off calendar, is that an action in itself which should justify public comment?
Mm-hmm.
And I would ask Member Green for her opinion on that as well.
I'm not aware of any case law that specifically addresses this. I know that there's been at least one California case that provides that there's no requirement to permit the public to address whether an item should be added to an agenda, whether or not it should be removed. But looking at it as a practical matter, I would look at, even our own procedures. If we come in and Chris says items 15 and 16 have been withdrawn, they're withdrawn. We don't usually then proceed to have public comment on whether or not they should be withdrawn or on the substance of them. They've just been withdrawn. And that's, I know, how we as a body have operated in the past. Where there's an issue is to continuing a matter where, especially where we've heard partial testimony, there's a dispute as to whether it's appropriately continued. Sometimes through the chair, I believe it's the chair's discretion to have public comment on that. But I know in instances we haven't allowed public comment on whether or not a matter should be continued. So, based on this board's own precedents and the lack of other case law, I think as long as it's announced at the beginning of the agenda, which is a requirement of our sunshine ordinance for changes to an agenda, that something's been withdrawn, I actually don't see a requirement to have public comment.
Just to cloud the issue a little bit further, one thing that I noted is that at our meetings, if an item is announced at the beginning of the meeting as being withdrawn, then members of the public can get up and comment on that item during general public comment as a non-agended item. At board committee meetings, I've noticed that there is no general public comment. So that's an opportunity to be taken away. I don't know if this really enters to the legal technicalities of what we're dealing with here, but I just thought I would kind of throw it out as food for thought.
Mm-hmm. That's actually the first thing I looked for on this, to see if there was an agenda item for general public comment, and there is none here. And I think that would be a way to address it, but that's not something that we can.
I have a question.
Member Washburn?
What does the law say about requirements for general public comment, or are there none? Do certain bodies have to have them and others not?
Not sure there is anything in the law. Mr. Laurenti, Member Craven Green?
6715.
Yeah, on 6715 of the ordinance, every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body on items of interest to the public that are within the policy body's subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda unless action is otherwise authorized by 767(7)(e). That's generally how the provision under which we have public comment. Mr. Laurenti, I don't know. I was not aware of the fact that this committee, the Rules Committee, didn't have general public comment. I don't believe it's a requirement of the Brown Act. But so the state law, I think, is silent on it. And then we have this provision, 6715A, that I think the intent is to require general public comment, but I would defer to Mr. Laurenti.
I would tend to agree. This basically says that the Board of Supervisors need not provide public comment on an agenda item if it was provided at the committee level.
Well, that's a different issue, though.
Right.
That's comment on a specific agendized item. The Board of Supervisors does not need to comply with public comment if it was fully discussed and publicly aired at the committee. But Member Washburn's question is more general. What about general public comment?
Right, and I don't see anything in 6715 that really addresses the opportunity of general public comment.
Member Coughlin.
The way I read this, and I do recall this because it's an issue of great interest to me, that there is a requirement that agendas of all policy bodies and committees are also policy. Committees of larger bodies are also policy bodies. And then I also want to talk about the spirit of sunshine. It seems to me that in the spirit of sunshine, if somebody wants to talk about an issue, even if it's been withdrawn, that there should be a provision. Well, they should be allowed to, and B, there should be a provision. Maybe we should be telling these departments that maybe they should make a provision for general public comment on their committee agendas. I mean, I would certainly recommend that. I mean, I'll even put it in the form of a motion.
Member Williams.
I also concur with Member Cawthorn that I saw that meeting and they didn't have public comments, and I was surprised. And I believe as residents of San Francisco, any kind of meeting, public meeting that's being held, the public have a right to speak. Public have a right to speak. This is democracy. And it feels like, to me, democracy has just been taken away from the people here. And the only reason that I'm still on this board and I'm not leaving, I'm going to stay here until we get this sunshine right. We have not, it's just not tight enough for me. And I concur off the agenda. I can understand how some people feel because I'm sitting here watching while people laugh. And I take offense to that. We're serious.
Speak into the microphone.
We're giving up our time. And we're not a joke. We're sitting up here trying to serve the people, to ask to their rights, even as to the last lady that just walked out of here, human rights. She shook her head and like, it's nothing. And it's really very offensive to me for us to come out here to try to serve the people. And even the audience, they can see the other people, how they take approach to us. Except the police officer, he was very intelligent, how he came and paid prompt attention to us, and he listened. But I'm watching the others. They've not been more paying attention to us than the man in the moon. Half of them laughing, like he says. And the other lady, she did not even come prepared. And when we said no motion, she just walked out the door and shook her head like it wasn't even anything. And that's inappropriate and that's unacceptable. So something has to be done. We have to get stronger with this, and I'm very, very concerned about this, Member Nee. It's a lack of communication around here, and I'm really concerned about this.
Okay, Member Kneber and then Member Cawthon.
After rereading this, I tend to agree that 6715A, I mean, reading it over and over again, I do think it says that there should be an opportunity for public comment on anything within the policy body's subject matter, jurisdiction. So I would move that we find a violation of that. Okay.
Sorry.
I don't believe there is.
I don't believe there is.
Not a motion to find violation. I moved that we inform the Board of Supervisors that we recommend general public comment at all committee meetings, and in fact, 67.30C does require that when we report to the Board of Supervisors annually on any practical or policy matters. So I don't want to step on your motion, but that would be my motion.
Okay.
Just for clarity, I mean, I think we have a complaint.
Yes.
And the complaint before us is that they did not provide for public comment on an item that was withdrawn. Yes. So that issue we have to address. That's the issue that's in the complaint. Yeah. If we want to do something different, then we can do something different.
Could we separate?
Well, I do think, and that's correct. But the idea, I think, 6715A covers anything under purview, including an item that was withdrawn, because it's no longer an
Okay,
agenda.
before we proceed any further, is there a second to Member Cawthon's motion?
My motion was to recommend to the Board of Supervisors that they make a provision for general public comment at committee meetings.
Okay, it's been moved and seconded. Mr. Laurenti?
Yes, I just want to provide the task force with. I'd like to read 6715E because I think it's relevant. It was referred to in Section A. And basically it says, to facilitate public input, any agenda changes or continuances shall be announced by the presiding officer of a public policy body at the beginning of the meeting or as soon thereafter as the change or continuance becomes known to such presiding officer. I only mention this because if you take the withdrawal of an agenda item, that is an addenda change. If that's the case, how do you facilitate public input if you don't provide public comment on that? So that's just.
I would tend to agree, and that's why I would still like to say that as a 6715A.
Are you moving to find violation?
I am moving to find violation of 6715A as a separate.
Based on what?
Well, based on the fact that it says that, this was an agenda item. Once it's taken off, it's still under the purview, under the jurisdiction of that committee, and there is no opportunity for public input. It says that it has to, any members of the public to directly address a policy body on items of interest to the public that are within public policy body's subject matter jurisdiction. So there has to be a way for the public to comment on anything within its jurisdiction, and I know that it's a fine line and that this is a withdrawn item, but because you can't comment on anything, you're not allowed to comment on a withdrawn item. I hope I'm being clear.
So I don't necessarily agree, but the motion would be to find a violation of 6715 for failure to provide general public comment.
Yes, and I think that moves into this because there's no opportunity for them to comment on a withdrawn item, whereas there was...
maybe you'd want to say then, for failure to provide general public comment or otherwise allow members of the public to comment on agenda changes?
Yeah, I would agree with that.
Is there a second?
Excuse me, is there a second?
Second.
Okay, it's been moved and seconded. Member Cawthon, I believe.
I would like to recommend that the order of determination also, or either this be severed and we vote on my motion, that either the order of determination include a request under 67.30C, I believe it is, that the supervisors do provide an opportunity for public comment at committee meetings. And if I can't go in the order of determination, then I would make that as a separate motion.
Mr. Knibber, were you offering your motion as a substitute motion to Member Cawthon's motion or as a separate motion?
Separate motion.
Okay, separate motion. Okay, in that case, what we'll do is discuss Member Cawthon's motion first. Mm-hmm. We'll deal with that first, and then we'll deal with Mr. Knebber's motion. Both motions have received seconds.
Okay, so my motion just basically is to follow the tenets of 67.30C, which says that when we make an annual report, we're supposed to report annually on any problems we see in the administration of Sunshine. Maybe we could make this recommendation a little bit early.
Okay. Any further discussion? Member Washburn.
Well, I'm wondering just how broad this problem is. The Board of Supervisors committees don't seem to offer general public comment. This could be a widespread problem, in which case, yeah, we have a real problem with sunshine in this city. So I don't I don't know whether we should, amend Member Cawthon's motion, or, I don't know, agendize this for some other time to, do some investigation here. But it seems to me that there might be a number of policy bodies in this city that are breaking the law, sunshine ordinance.
Member Craven Green.
I mean, the issue I have with Member Cawthon's motion is that I would style it more as a letter through the chair of concern that we've been informed that committees are not following what we believe is required by 6715A, which is to have general public comment even at committee meetings. Because the Board of Supervisors, isn't here. This is against the Clerk of the Board and Supervisor Chris Daly. I'm just not sure procedurally how appropriate it is to have a motion, to use the motion mechanism to make the point Member Cawthon makes. And so I would support the impetus behind it, but I think it would be better styled as a letter coming from the chair to the President of the Board of Supervisors and the chairs of the committees, each of the committees.
Are you offering that as a substitute motion?
I will offer that as a substitute motion.
Well, my suggestion was that
Excuse me, the substitute
Sorry.
motion has not received a second.
I will second that.
Proceed, Member Cawthon.
My recommendation was that the order of determination also incorporate what Member Craven has just suggested. So there are two ways of doing it: incorporated in the order of determination, or pass it as a separate motion, or pass it as a substitute motion. I'm happy for all of them. I just want them to get the message.
Procedurally, Mr. Lorente, what do we do?
I think procedurally on this, I mean, an order of determination, you have to make a finding of a violation. On the other hand, a letter from the chair is basically an instructional letter, which doesn't have the force of, hey, you made is basically to assist in terms of a potential issue that needs to be addressed in the opinion of this task force. This has come to our attention. We believe that under 6715 there should be an opportunity to be able to speak, especially on items that have been withdrawn, as an example. And I think that that's a vehicle that would work. I mean, to use the violation concept is to basically stretch 67.15a, which is within your prerogative. The question is, how much traction would you get off of that? So you have two ways in which you could get the message across, by way of letter or by way of an order.
And you're saying it's an either or rather than both?
I think it's an either or. I don't think you can find an order then do. I think that in this case it's a close. There's nothing here that specifically says there has to be. However, it's clear from reading this section that that the intent is there. I mean, there is the feeling that the sense is that it should be, and this would be a way to get them to think along those lines.
Right, but let me just clarify. I mean, I don't think there's anything inconsistent with the chair sending a letter to the clerk of the Board of Supervisors and the chair of the committee saying we believe 6715A requires general public comment, and an order of determination proposed by Member Neber finding a violation here based on their failure to provide general public comment or otherwise allow members of the public input on agenda changes under 6715A and 6715E. I don't think those two are inconsistent. I think perhaps having order of determination that Member Cawthon suggested and having a letter inconsistent.
Okay, yeah.
Okay, the motion before us right now is Member Craven's substitute motion. Is there public comment on Member Craven's substitute motion?
Yes, thank you. Peter Warfield. I'm not sure that I know what the substitute motion is anymore because there seem to be three motions that have been discussed. Thank you for taking public comment. I wanted to make some general observations about Section 67.15 and public comment that might bear on your consideration of this. I'm not familiar with the case. It says that every agenda for regular meetings shall provide an opportunity for members of the public to directly address a policy body on items of interest to the public that are within the policy body's subject matter jurisdiction. and goes on. I like the Ethics Commission, which has on its agenda what is generally known as general public comment, where it says public comment may be taken for items, and I'm recollecting now, whether on the agenda or not on the agenda. At the public library, they did what I think is correct until very recently, and that is they said public comment, just pretty much what this provides, on anything within the purview of the body. As soon as you restrict public comment, as I believe your agenda does and a number of other agendas do, to material that's not on the agenda, you first of all burden the public with trying to sort out, is it or isn't it on the agenda? Is the wording of the agenda something that would prevent me from saying it during general public comment? In an 80-item agenda, like the Board of Supervisors has, that's quite a job sometimes, especially when things get technical, or at the Planning Department or Board of Appeals. So I think, first of all, it burdens the public. Second of all, what happens if you lose quorum? And now people who came for an afternoon or an evening didn't get to speak on general public comment because the item was item 6 or item 60 on the agenda, but then it wasn't taken up. They've been basically faked out, if you like, to use an old ball game phrase. So I think there's a real problem in how you phrase the general public comment. Of course, you might ask people to hold it because we're going to take this general subject up at item 7, but that seems to me a problem about loss of quorum, or for some reason putting it off, or somebody didn't show up, and so you say let's continue it till the next time, and all of a sudden all the people that expected to comment on item whatever don't get to. Another issue is that on item C it says each policy body shall adopt a rule in the middle of it, providing that each person wishing to speak on an item before the body at a regular or special meeting shall be permitted to be heard once for up to 3 minutes. Well, is the item to be taken up if it's on the agenda? Some people may have taken childcare, they may have taken time off from work, they may have gone to considerable effort to come to a meeting and talk on item X, and now all of a sudden, even at the beginning of the meeting, it said that it's not going to happen. So now what do? Pack up their bags and come back another day when the same thing might happen? I think you lose a lot of members of the public ultimately who are going to say, I can't do this over and over again. So much as I like the people who are involved and know the people to some degree who are involved, and I hate to contradict them at this moment, I think that you really need to consider seriously what public comment has to say and what the requirements are for each agenda item, whether or not it's been removed. If it's on the agenda, I would say let people talk.
Thank you.
Thanks.
Ray Hartz, and I'll give you a hypothetical. I'm a member of the Board of Supervisors, and I have a proposal that I want to put forward that is very unpopular for a lot of people and only pleases a couple people. I walk into the committee meeting and I look out in the audience and I see one person I know who I know is there for that item. And I also notice they're sitting and talking with about 30 other people. And I say, can't have it today. Put it off till next week. Put it back on the agenda. I look at now there's only 18 people. That's still a little too much. I'll put it off till next week. And they keep doing that until there's 1 or 2 people. Those 1 or 2 people get up and they make the comments that the other 25 or 30 wanted to make, and I've met the obligation. Now we go to the full Board of Supervisors. This item comes up before the full board, but because we allowed public comment in the committee, they're not allowed to comment on it now. So the way to disenfranchise those who want to talk about an item that is generally unpopular, but is something that I, for whatever reason, want to get through, I just do a little parliamentary maneuver and just cheat you out of your opportunity to comment. I discourage people from showing up at future meetings because they figure, hey, why bother, because I'll just show up and they'll just take it off. So anything that I feel is questionable and is going to raise any questions, I will simply do the political wise thing. I'll remove it from the agenda at the last minute. I'll let those people walk out all annoyed, knowing that it'll be very hard for the person coordinating them to keep up the energy for as long as I can. And I will continue to do that until such time as I get it through the committee, and then I'll pass it on to the board, and when they come up to speak at the board, I'll simply say, nope, the rules say that if we spoke in the committee, you didn't come in the committee, so you're out of luck. And they will either click the microphone or they'll call the sheriff. So I think it's simply a maneuver. If I agree with Mr. Schneider, if there is to be error from a public servant, especially members of the Board of Supervisors who, if you ask them, would say, oh, yes, I believe in open government. it ought to be let them have comment. If they withdraw the item, they should be able to comment on the fact that it's withdrawn and to raise objection to its withdrawal and to say, we're all here and we don't want to do this again. Please don't pull us. Now, bottom line is they are politicians, so guess being political is their second nature. But I think as far as the committee, I would certainly encourage you to let the Board of Supervisors know that any meeting like that, where that's the only opportunity for the public to comment, they should be given that opportunity.
Thank you.
As you guys are speaking, I'm Rick Caldera, Legislative Deputy Director, and as you guys are speaking about the public comment portion, which is not on the agenda today, your item on the agenda today has to do with whether or not he took public comment on this one item that was withdrawn. And it is the policy. I just want to kind of give an overview. There's a handbook of rules and procedures that the Board of Supervisors utilize, and there's specific rules relating to the policy of the City and County of San Francisco and the Board of Supervisors encouraging and permitting public testimony before legislative action is taken by board. So in a sense, all of the committees, there's the committee structure, which everything happens in committees, and all of the public comment is allowed in committees. The specific item that we're talking about today is that this item was withdrawn, similar to your 15 and 16 on your agenda today. You've withdrawn 15 and 16. Yes, you do have a public comment portion on your agenda. On the committee level is where all the public comment happens. Since that item was withdrawn, there is a public comment portion at the Board of Supervisors for items that aren't on the agenda. The whole committee process, the committee system of the board is designed to hear effective public testimony for and against proposed legislation and to hear suggestions for amendments so that all those amendments can happen during the committee process before it actually gets to the board for actual legislative action. So all of the amendments and public comment and testimony happen at the committee level. And then it moves on to the Board of Supervisors for that final action, the legislative action. So I just wanted to kind of steer you guys back into, yes, I hear you guys about the public comment, and certainly I hear that maybe a letter will be coming to the clerk of the board requesting that there's public comment on these committee-type meetings. But there are rules and procedures that the Board of Supervisors follows in reference to public testimony and when and where it happens.
Thank you. Is there further public comment? Seeing none, public comment is closed. Task Force? Is there further discussion on Member Craven Green's motion? Okay, Mr. Clerk, please repeat the motion and then take a roll call.
Through the chair, I have to ask Member Craven to repeat the motion.
I believe it's a motion that through the chair, a letter goes to the clerk of the Board of Supervisors, the president of the Board of Supervisors, and the chairs of each committee expressing the task force's concern over the lack of general public comment at committee meetings and the task force's belief that 6715A requires general public comment at all policy body meetings.
Roll call, please.
On the motion, Member Craven Green?
Aye.
Member Craven Green, aye. Member Cawthon?
Aye.
Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
Aye.
Member Knebber, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan, excuse. Member Goldman?
Aye.
Member Goldman, aye. Member Williams?
Aye.
Member Williams, aye. Member Chu? Member Chu, excuse. Member Nee?
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Okay, and that takes us to Member Knebber's motion.
I believe Member Cawthon.
Yours was a substitute for hers. Member Knebber's motion to find violation, I believe, was 6715A. Is that correct? Okay.
And I would say E.
I would add that, but I didn't say that in my original motion.
Okay, is that acceptable to the second, to add E?
Second.
Okay. Is there public comment on the motion to find violation of 67.15A and E? Seeing none, task force discussion? Seeing none, roll call, please.
On the motion, Member Craven Green?
Aye.
Member Craven Green, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon?
Aye.
Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebba.
Aye.
Member Knebba, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
No.
Member Goldman, no. Member Williams. Aye. Member Williams, aye. Member Chu. Member Chu excused. Mr. Chair, we have 7 ayes and 1 noes.
Thank you. We'd like to thank the complainant and the respondents both for attending. Thank you for your time and your comments. Mr. Clerk, would you call the next item, please?
Item number 9 is the determination of jurisdiction on the complaint filed by Bridget against the police department for allegedly withholding public information.
Thank you.
And once again, members, I move that we find jurisdiction on this item.
Moved and seconded. Discussion? Is there public comment on jurisdiction of this matter? Seeing none, public comment is closed. Roll call, please.
On the motion on jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebba. Aye. Member Knebba, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. Is the complainant present? Please approach the microphone. Thank you for coming. You have 5 minutes.
Thank you. Good evening. My name is Bridget Lee Brady, and I'm a law student at Golden Gate University School of Law. This summer, I participated in a clinic with Golden Gate that was in partnership with the Homeless Advocacy Project, and we represented a client in a eviction action. The landlord filed an unlawful detainer against the client, alleging, among other things, that he had assaulted his neighbor. During the discovery process, opposing counsel indicated that they would introduce this incident report, presumably along with testimony from either the neighbor or the police. So I went to the Hall of Justice to request a copy of the report. And I was denied a copy of the report. The woman at the window told me that I needed written permission from one of the parties involved in the incident in order for her to give it to me. I did obtain written permission from my client later that day, but it was my understanding that police reports are generally public record and are available to the public for viewing. I also understand there are exceptions to that rule, which the police indicate in their answer that there are exceptions, but I don't see how any of those listed apply here. The police cite the vehicle code, something about sexual assault, neither of which are relevant. They also cite the San Francisco police policy as though that trumps city and state law on public records. So while I understand that there are exceptions to the rule, I don't understand how that applies here. If this particular report is not a public record, then I don't understand what would be. This was an alleged altercation between 2 adult men. There was no arrest made, so there was not an issue of pending charges or anything of that nature. So I just wanted to ask the committee to require the police department to make this report available to me and to any other member of the public who wishes to view it. Thank you for your time.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present?
Good evening, Lieutenant Daniel Mahoney, San Francisco Police Department, and with me is Attorney Ronnie Wagner from Police Legal.
So the department agrees that sometimes, and maybe generally speaking, there is an opportunity for
police reports to be released as public records. However, here a complaint's made, but there's insufficient facts for the department even to attempt to cure the complaint in the first instance because, well, the complainant knows what the report is, the department doesn't. So the complaint that's received articulates an alleged refusal to disseminate a report, but we don't know what it is or from whom it was requested, and there was no way to attempt to contact the complainant because they didn't even provide their own name or contact information. So we don't know where in the Hall of Justice the person reported to request the incident report. We don't know anything about the report. We don't know, and the references to the vehicle code and other sections that are legal bases on which to deny release and dissemination of reports or exactly what the department has to have the opportunity to review the report to understand. Is there a 293 victim who has the right to invoke confidentiality, such as that their name and identity would be redacted prior to release?
And a 293 victim is?
Is a sexual assault victim. Is
Thank
there a
you.
juvenile mention that you would be required to file an 827 Welfare and Institutions Code petition to be reviewed by the juvenile court? The department can't, even though notwithstanding the Sunshine Ordinance, we don't release police incident reports willy-nilly without reviewing them. Similarly, if, for example, now we know that this purports to be an incident concerning a dispute between two individuals. So we also, the department has the opportunity, should have the opportunity to review that to see whether danger could come to one person. For example, if the person who's requesting the report might bring harm to the person who is a victim. So without knowing what's requested, there's no blanket answer to whether the report should have been disclosed at that juncture. There needs to be an opportunity to review what's in the report to see what, if anything, should be redacted.
Thank you. I would ask that when you're going to throw out code numbers, please explain them, so that a lay citizen can understand them. You mentioned the 293, and then there was one other reference you made to a numeric code. Could you review that? And
Welfare and Institutions Code Section 827.
Mm-hmm.
When juvenile records are requested, they are presumptively confidential, and they can't just be disseminated. It's actually a violation of statute to do so. That kind of request needs to go to the juvenile court, and they conduct a review in camera.
Okay, thank you. Sir, the 5-minute clock is still ticking.
No, we're fine here. The main issue that we had was that the complaint really had no information for us. We had no information to go on, whereas to where she went to, who she spoke with to either clarify or even affirm that these facts even happened. We were not given the type of report or even the report number. We probably could have cured this complaint rather simply had that been in the official complaint itself. But the contact information was redacted even, so we couldn't even contact the complainant to find out what she needed. And that would have gone, I think that would have gone a long way.
Thank you. Thank you both. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Member Craven Green.
Yeah, the representatives from the department, I could ask you just a question. So just standard operating, the issue here appears to be that when the law student went up to the window and said, I want a copy of the report, they said you have to have a signature from a party to the incident before it's released. So I want to know, is that normal operating procedure?
I don't know still which window she purportedly approached.
Okay, let me ask a different way. I want to go down to the Hall of Justice tomorrow and get a copy of an incident report. Where shall I go?
Go to room 475.
Okay.
The record management system.
So if I go to room 475 and I say I want a copy of an incident report of an incident that took place on 500 block of O'Farrell at 10:30 p.m. Friday night, will they give me that report after they have conducted a review to make sure these exemptions for victim of sexual assault, other issues don't apply?
Yeah, there are a lot of other issues, but yes, they will.
Will they require me to get the written permission of a party to the incident before releasing it?
Not that I know of.
Okay. So basically, it sounds like what we have here is that perhaps the person that the law student spoke to gave her bad information. Would you agree with that?
That's a fair statement. If
Right. I mean, based on what we know about,
that is in fact what happened. Yes.
Based on what we know about the nature of the incident, 2 adults, no sexual assault, no vehicle involved, no juvenile involved, it would seem that if, in fact, she was told she needed to get a signature from her client before it would be released, that was incorrect. Would you agree with that?
I don't know. What do you think? I don't know. I can't answer intelligently that. It sounds like from what she stated about the report itself, it probably sounds like she should have gotten it,
Right, without getting a prior written consent.
Right.
Okay. All right. Thank you.
Okay. Is there public comment on this matter?
Early in the evening, Member Williams said, I haven't seen you in a while, and most of you are probably going, God, I hope we don't see him in a long time from now. I think what we have here is, from the old Newman movie, a failure to communicate. The Sunshine Ordinance provides very clearly what should have been done in this position. If they need time to review the document to ascertain whether or not it falls under those restrictions, what they say is we need an extension of time. We can't provide it as an IDR, but we can give it to you in 10 days or sooner if we can complete the review. And they failed to do that. What they told them instead was you need somebody's signature, which turns out not to be probably true, but nobody can, I think, clearly answer that. But what I'm saying is whenever you approach the police department, no matter where you go, even if it's to the Hall of Justice, you can't find someone there who can answer the question. And if you press it, they get angry with you. If you say, well, can I speak to somebody who can tell me the answer? I just told you the answer. Well, no, you didn't. You told me what you think the answer is, and you also admitted that you don't know what the answer is. Is there someone in charge? Well, they're not available. So you go round and around in circles. So really what we're taking here is another instance of the police department being unfamiliar, even of its own record keepers, as to what they are permitted to release and what they're not, and the fact that they have the option that if they have the question that they need to review it, they can simply say to the person, I can't give it to you today, but after the review, we can give it to you. They would have completely been on the right track. But instead what they did was this, and I think really what it is as you talk to each of the individual people, whether it's a police officer or a civil servant, they just basically tell you what they think rather than what the law is. And they sometimes go by the seat of their pants and make it up as they're going along. But the default position is, no, we're not going to give it to you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Task Force? Before we do, at this time, we will give the respondent and then the complainant 3 minutes each to make any concluding or rebutting remarks.
Yeah, just one point. Since I just met with her, I've given her my business card. I've taken down the report number, and I'm arranging to get it to her tomorrow.
Okay.
And I would just say that when we're the legal division, we are not the records management section. So we are responsive to inquiries, and we do go by the state of the law. So if somebody brings their name and contacts us, we will respond timely and based on the law.
Thank you. And would the complainant like to make any concluding or rebutting remarks?
Yes, thank you. I did report to room 475. It was window number 1. I included in my complaint the date and time that I was there. I'm sorry I did not make my contact information public when I made the complaint to the Sunshine Ordinance. I didn't feel comfortable doing so at the moment. But when I reported to window number 1, I was told I needed to fill out this form to request the incident report. I had the incident report number and explained who I was and why I was there. I was asked for a photo identification, which I gave. And the woman took my report request back and presumably looked at the report to see what the nature of it was before coming back to the window to tell me that she couldn't give it to me. So, I mean, the respondents didn't seem to even know if that was their standard procedure or not. It did seem like it was to me. The woman just said, well, you know, you need written permission from one of the parties. I very much appreciate the fact that the officer has given me his business card and is going to get the report to me. But the reason I made the complaint was so that maybe that this could come to light that this is how they operate at room 475 at the Hall of Justice, and I think that that really needs to change. So thank you.
Thank you. Just one comment. Ms. Brady and everybody here, while certainly we encourage people coming before this body to identify themselves, it helps for our own record keeping, for complainants and for members of the public who wish to speak. There is a right of anonymity. Task Force? Member
I just wanted to
Craven?
make a comment. I mean, I was looking at 67, or the information that must be disclosed, and I mean, I do agree that they have worked this out, and I think that, in my opinion, Lieutenant Mahoney has, since he got into the legal department, I think he has done a lot to observe sunshine. My own experience, I think it's room 475, is that it's nowhere anybody should go who really wants some justice regarding sunshine. There seems to be a perception that you're there to find something out about them they don't want you to know, and it's very unpleasant. So I could agree with Mr. Hartz, and I could agree with Ms. Bridget as well. And as I say again, I think that I'm very pleased that Mr. Mahoney has offered her the document that she seeks and his card.
Member Williams?
I just want to say I've been on both sides of the fence, and really, I just thought the police was just horrible. But when you come out to send Lieutenant Mahoney, since he's been in there, and I've had some last dealings with there, it seems to be getting better. And I think sometimes people have bad days, and maybe you reach the wrong person. You reach the wrong person, and it's all the police department is not all bad. They do have some good people, but sometimes they can be top ego. So I really appreciate Lieutenant Mahoney being here today and speaking, because the police department do have a bad name, and they can kind of get rough on you. Even me, I have to deal with them a lot. But lately, since he's been here, it's getting to be kinder, gentle. So I appreciate you coming forth, and I hope we keep it up. And it's a lack of communication. I think the whole system is a lack of communication. Everything that we have gone through since I've been on here 10 years is simply that people do not communicate with each other. If you do not have the records, simply send it back and say, I don't have it, but I will get it to you. It's so simple, and we're making everything so hard for everybody. Thank you very much.
Member Goldman?
I move that we find the department in violation of 6721A for withholding public information.
I second it.
Member Neber?
I would like to add to that 6727 for not providing a reason for withholding it, 6721A.
Okay.
If that is amenable.
Okay.
Maker accepts. Does the second accept?
Yes.
And I'm wondering if 67.24 is relevant here also.
I would say 6724D. It's very broad, though. I mean, I haven't read it very carefully, but that certainly does clarify that for general information, it certainly is sunshineable. Mr. Lorente, what do you think about 67.24D?
D?
Broad. Very broad.
Yeah.
I think it's fine. I mean, we have cited it before where there's been a failure to produce law enforcement records. I mean, essentially, it requires certain information to be produced. What most police departments do to comply with that is to release incident reports or police reports unless they fall within the identified exemptions.
So you folks want to add that as well? Make or
Yes.
accept? Second accept?
Through the chair, will this be followed up at the next CAC meeting to see if it's been complied with?
Yes, the matter will go to compliance and amendments. Thank you for your question. Okay, further discussion on the motion.
I would just like to have, through the chair, have the motions read again, all the way through.
Okay. Mr. Clerk?
Through the chair, what?
The motions.
Please
Motion
reread the
is-
motion.
I did not hear Member Goldman.
Violation of 6721A, violation of 6724D, and violation of 6727.
Yes. 27D or just 27?
Just 27.
Okay.
Member Washburn?
I think this particular matter reminds us of the need for education for frontline employees. I think that very often people are multitasking. They have very diverse job duties, and simply don't know what they're supposed to be doing. And we talk about wanting to offer this service. I think we just talked about it with Lieutenant Mahoney even. And so I just wanted to remind us that this is something in our purview that we ought to, it might help solve a lot of problems if we can figure out how to do it.
And Member Nee, when we're quoting these violations, would you please tell them what the violations is and not the number? So I can see them said, as we say the violations, would you tell them what the violations are?
Okay, these will be elaborated in the order of determination.
Okay.
But yeah, you raise a good point, Member Williams. As I requested the representatives from the police department not to throw code at us without identifying what it represents. It's always a good idea for us to speak in terms that everybody can understand. So when the order of determination goes out, the code sections that we are citing will be explained. Okay. Further discussion? Roll call, please.
On the motion, Member Craven Green.
Aye.
Member Green, aye. Member Cotton. Member Cotton. Aye. Member Cotton, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebel.
Aye.
Member Knebel, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu, excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. Thank all of you for being here with us today. At this time, we will declare a 10-minute recess. Mr. Clerk, could you call the next item, please?
The next item is item number 11, which is the determination of jurisdiction on the complaint filed by Anne-Marie Mabut against the Department of Recreation and Park for allegedly violating Section 67.21 and 67.25 of the ordinance.
Member Goldman?
At the risk of sounding like a broken record, I move that we find jurisdiction on this item.
Is there a second? Moved and second. Discussion? Is there public comment on jurisdiction of this item? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebel.
Aye.
Member Knebel, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu, excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Okay, is the complainant here? Please approach the microphone. Thank you for coming. You have 5 minutes.
Thank you for your time today. My name is Anne-Marie Mabbitt. As I acknowledged at the pre-conference hearing on August 11th, over the past 9 weeks, I have submitted numerous immediate disclosure requests to the Recreation and Park Department. but nothing in the Sunshine Ordinance or any other applicable public records disclosure laws restricts the number or extent to which members of the public are able to submit immediate disclosure requests. I would like to note for the record that not once in the past 9 weeks has the Department attempted to argue that the records requested were not clearly public records. The Department has simply stopped responding to any of the requests as an immediate disclosure request and has repeatedly stated that it is now responding to my requests one at a time. I submit that this is a clear violation of the Department's duties and obligations under the Sunshine Ordinance. I acknowledge the Department has promptly responded to many of my requests, but other IDRs have been completely ignored or responded to partially and or with what appear to be clearly unauthentic and quite possibly tampered and or forged documents. I've attached as exhibits for today's hearing numerous examples of such responses. And I would like to note for the record that if I included every example, the exhibits would probably have numbered in the hundreds. I would also like to note for the record that any repeated or excessive reference by the Department to immediate disclosure requests that have already been fulfilled is neither proper nor relevant to today's hearing. As I understand it, today's hearing is to determine if the Department is currently in violation of its duties and obligations under the Sunshine Ordinance, including but not limited to Section 67.25A, 67.25D, 67.21A, and 67.21C. I am respectfully requesting, after a careful review of all submitted evidence, that the task force make a determination in writing as to whether the Department is currently in violation of its duties and obligations under the Sunshine Ordinance. And if such a determination is made, to demand that the Recreation and Park Department immediately provide me with any and all responsive documents that exist to all timely and properly submitted immediate disclosure requests that are now overdue. In particular, I want complete and authentic responses, including original copies of any and all responsive documents to the following immediate disclosure requests. Items number 2 and number 5 in Exhibit number 1, items number 2 and number 7 in Exhibit number 3, item number 44 in Exhibit number 6, items number 34 and 35 in Exhibit number 7, items 43 through 45 in Exhibit number 9, item number 1 in Exhibit number 12, item number 60 and 62 in Exhibit number 14, number 27 in Exhibit number 19, number 1 in Exhibit number 20, and number 1 in Exhibit number 25. I tried to keep everything as clear as I possibly could for the task force. I want to state for the record that I expect complete and authentic responses to all the overdue immediate disclosure requests I have submitted, but if forced to prioritize, I would consider the above-mentioned immediate disclosure requests as the most urgent. As Section 67.1A of the Sunshine Ordinance specifically states, government's duty is to serve the public, reaching its decisions in full view of the public. In regards to the athletic field and tennis court permits that were issued by the Permits and Reservations Office of the Recreation and Park Department for at least summer 2009, and in regards to the ordinance that incorporated these fees that the permits were based on, the Recreation and Park Department has clearly breached its duty. Having reviewed the responses received thus far from the Recreation and Park Department, it appears that numerous Recreation and Park Department employees saw fit to offer secretly and selectively permits at 62% less than the fees required under the Park Code at that time. This apparent misconduct cost the residents and taxpayers of the City and County of San Francisco more than $100,000 in the form of undercharged fees for summer 2009 alone. All the immediate disclosure requests I have submitted have been in an attempt to determine the origin of these permits and the fees based thereon. Thank you for your time.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent please approach the microphone?
Good Good evening, honorable members of the Sunshine Ordinance Task Force. My name is Olive Gong, and I am custodian of records for the Recreation and Park Department. In the last 2 months, we have received 124 requests and 81 emails from the requester. See Exhibit 8. These are detailed emails printout of Anna's requests. They are 69 pages of requests for public documents. The department has responded diligently and regularly with written responses and documents and have devoted as many resources as could be made available to the tasks that the requests have required. This includes analysis of these complex requests, consultation with persons who could assist in providing responses, searching for the potentially responsive records, reviewing the records when located, preparing the written responses to the requests, and disseminating the responsive records. In the space of 2 months, the department has responded by sending the requester 88 emails, 147 emailed documents in response to a request, and 337 hard-copied documents. The complainant does not. See Exhibit 3, the department's emails to the requester. With the exception of her first few requests, all of her 124 requests are labeled as immediate disclosure requests. You can see Exhibit 2, the screenshot of requests, all saying immediate disclosure. We have been unable to meet all her immediate disclosure deadlines for 2 main reasons. One, while some of the requests are simple, many of the requests require an extensive search requiring hours of staff time to look through records. The records must be routine, simple, and readily available to qualify as an immediate disclosure request. And many of her requests do not qualify. For example, of the first...
Excuse me.
Yes?
Member Cawthon, could you refrain, please, from doing that on... It's registering on the microphone.
Okay.
I'm sorry. Proceed, please.
Okay. For example, of the first 30 requests, 14 do not qualify as a routine, simple request, but require an extensive search and involve voluminous records. Of the 125 requests that we have on the list in Exhibit 1, the list of all the requests, 67 of them are require an extensive search. Secondly, we have been unable to meet her deadlines because due to the sheer number of requests, there is not enough staff time to fulfill them all. These are difficult budget times, and the department simply does not have the staff to fulfill all these requests in the time period that she would like. Over the last 2 months, staff has spent many hours per week and sometimes many hours a day working to respond to these requests. Given the volume, scope, and frequency of these requests, we have asked the requester to prioritize her requests, which we will respond to one at a time. A decision to handle one request at a time was made so that staff would be able to continue performing its regular duties, including the duty to respond to public records requests from other individuals. Complicating this, the voluminous nature of her requests is that she frequently reprioritizes her requests. In Exhibit 7, we see 4 instances where she reprioritizes her request so that, again, this is a very confusing process. We're working on something and then she reprioritizes. The rights of the public under public record laws are subject to an implied rule of reason. To hold a city department to strict time requirements, irrespective of the burdensome nature of an individual's request, would create a situation allowing a single individual to monopolize the resources of a city department. Such a construction of the Sunshine Ordinance would violate the rule of reason that applies to laws governing the public's access to public records. Let's see. The department reviews documents to ensure that there is no personal information given out. We do not alter them in any way before we give them to the requester. In regards to your allegation that the department withholds documents, the department notifies the requester once documents have been received and reviewed, and it is in Exhibit 6. You can see emails showing the rolling nature of the department's response.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
I would like to talk
Member
to
Costin.
Ms. Mahmood. I just wondered, could you let us know what you don't have at the moment?
What I don't have is probably the majority of what I've asked for to this point. The items that I mentioned in particular that I've prioritized as the most urgent. Item 2, I mean, I'd have to look through my things, but item 2.
Could you just sort of estimate as to what percentage of what you asked for did you get? About 50%?
Yeah, I'd say about 50% at this point.
So can you work, we had a case that I recall, I've been on this task force a long time. There was somebody who was making a request for a lot of documents, and they were able to work out a plan for producing the documents. Now, would you be willing to work with something like that, or do you need them right away?
Well, I need them sooner than later, and I feel I've already done that. I've issued. They've asked me to, even though I don't feel I'm required to prioritize my requests. I've done that on numerous occasions, not to confuse or burden them, but obviously there's been a drag in responding to these requests. So at certain points, I realize there's most likely no chance they're going to turn over the documents. So I may have dropped a request and then just moved up the next one in the line. But like for right now, the 3 of the documents I'm particularly interested in that I've requested, and this original one was requested, I believe, sometime in June, and that was a copy of any and all public notices regarding any public hearings that were held regarding ordinance number 090717.
Okay.
And now I've subsequently realized over the weekend.
Let me just break in for just one moment, if I could. That you say you've gotten about half of what you requested. Is the department going to work with you to provide you with the rest, or are there some documents they aren't going to give you?
Well, I don't know. I mean, I'll have to see. But there's requests that have been outstanding for
You filed
7
in
weeks now.
Did you file in July? Was it in July when you first?
No, some of these requests were first filed sometime in mid-June, and I still have not received a response.
Okay. The thing I'm asking is obviously that public documents are public records. I'm just thinking that there is a lot that you have asked for that you've gotten, and there's a lot that you have not. And I just wondered if you'd be willing to work with Ms. Gong to see if you could work out a plan to get. Has she said you can't have certain documents that you?
No,
Okay.
but they've not been turned over in nearly 8 weeks' time. And I must say, look at how long it's taken to get the information I've got. If I'm going to label these things as a normal request, I'm never going to get them. I mean, it'll be 3 months from now. So that's why
I'm going to stop my questioning, but I mean, I just want you to know that I make sunshine requests too, and I sometimes think when somebody takes a 14-day extension, I just wonder whether they're stalling or whether they're legitimately taking the extension. So, I mean, but I do realize there has to be some give and take, particularly when the requests are voluminous. So my only issue with you is to encourage you to keep on working, and we're here to see if there has been any violations.
Okay.
So.
Well, I've tried to do that, and that's why I put in that paragraph about the specific documents that I consider most urgent right now. And all of those, I would like to state, are weeks overdue. So even if the department had properly requested an extension, they are clearly overdue at this point.
Okay. Did they request a 14-day extension?
And some they've requested extension, to others they just have not, or just issued the standard response, or answering a request one at a time, and that does not meet the requirements of the Sunshine Ordinance.
Okay, well, thank you for clarifying that for me.
Well, Member Nee.
Member Williams?
This has been one of the best, made my day. She has outlined everything in the world. And I just want to say that you've asked for a lot, more than anybody I've ever seen. And they look like they have complied with some of your wishes. So I'm like Member Cawthon, if you could just kind of work with them, because this is really a lot, you know. But they look like they have tried to concur. Yes, coming back.
I'd like to state the voluminous, extensive request required of a lot of these requests, I take objection to.
Okay.
And I'd like to note that one of the initial requests that I had placed back on June 18th or 19th was for records of permits going back to 1984. I received responses to those requests in less than a week. It was only almost to the day that I submitted the request for the notices regarding public hearings that the department started saying they were going to respond to my requests one at a time.
No, I don't mean to imply that it was so voluminous that you shouldn't. You can apply for anything you want. I mean, if it's a mile high, I mean, it's your right to do that. But I just want to see if you two could work together, too.
I mean, I would like to work because I would like to get the documents. But just, I would state for the record that with the exception of one immediate disclosure request that I've made that's currently outstanding, none of the others require any extensive search. They're fairly straightforward. They're easily and readily available. They amount to probably less than 25 pages. And as far as the total number of pages that have turned over to me, I mean, we have a laser printer at our house that can print out 1,000 pages in half an hour. So I don't find 800 pages, while it may sound like a lot, some of it was not really potentially damaging to the individuals involved, so of course it was turned over easily. Much of what's remaining is very incriminating, and thus I submit is why it's not being turned over immediately.
So you have something, you said 3 things that you need, that's priority that you need right now. Is that what you
well, there's all of the ones that I put here, but I would say in particular there's maybe 4 or 5 items
that you need
that I would like right away, or at least an answer. If there are no documents responsive, then I want the department to state that in writing.
Okay, all right, thank you.
Okay.
At this time, we will take public comment on this matter.
I'd like to echo the idea that the complainant has really, from what I can see, made an effort to work with them. They asked her to prioritize the stuff, and then when she did, they complained about the fact that she changed the priority. Well, things change. So what I don't hear from the department is a willingness to work with her. What I hear is this is a lot of work, this is a lot of time, this is a lot of extra, the effort, the budget's been cut, and rather than, we've given these things to her, we'll have everything else to her, we'll have these to her by this date or these to her by this date. So it isn't we're delaying or no, but what I hear is now we're starting to set priorities and say we're going to give these to you one at a time. And nowhere in the law does I see that's applicable. Now, if she's willing to take it that way, then that's more than her. I mean, that's certainly a prerogative. But what I would like to see is as much give and take on the city side as I do on the complainant side.
Thank you. Is there further public comment?
Good evening. My name is Andrea O'Leary, and as a park advocate for many, many years, I just want to say that this is a real issue with Rec and Park. This has been going on for a very long time. From my own experience, you have to make repeated requests. You can send emails, you can make phone calls, you can go before the commission over and over and over again. And there is always an excuse why a response can't be made. There's no time, they don't have enough staff, the records aren't kept. It's constant. So this isn't just like a slight thing. This is a repeated thing. The new management structure there has this chain of command system that they want you to go through. but it doesn't mean that they're going to stick to their own command. So you go to one person who says, no, you got to ask somebody else. No, you got to ask somebody else. You get to that person who says, well, no, I don't want you talking to those other people below them. So there's no system where you can get answers to your inquiries. In particular, if it has anything to do with money, or if it has anything to do with something that the public specifically wants to work with the department on in their particular neighborhood parks. If it has to do with scheduling, if it has to do with why are you spending capital money on that instead of on what we have requested, there's just no response. So it's not like these are, we don't want to put in sunshine requests for answers to simple questions. But sometimes that's your only recourse, and it doesn't mean that you're going to get information. I was working with one group some time ago who put in a request, and of course they had to pay for every document. We got like 10 boxes of Xeroxed paper in absolutely no order whatsoever. The people refused to pay for it because it wasn't in any kind of order. So they had to re-Xerox the whole thing all over again. It came in manila folders that still made no sense, and it was all just duplication of the box before. So this isn't an easy task. Try to get on their website and find something. It is literally impossible. It's better because advocates have complained and complained and complained for years that information is not available. Management is ignoring the public. They don't want to speak to us. They don't think it's our business. And records are just simply not available. And I think that this kind of complaint is something that needs to be looked into for this particular this department in particular, because they have to work with the public. They are a public service kind of. We're talking about intimate public service. Your neighborhood park is like an extension of your family life, and people are trying to work with the department on very pedestrian level. And they need to have access to the public in a way that is easily discernible. Thank you.
Thank you. Further public comment? Seeing none, public comment is closed. Task Force? Member Craven?
I just wanted to ask Ms. Gong a question, if I could. Ms. Mabut identified 15 items that were her priorities to us. Now, I don't know how extensive those items are, but, can you work with her to make those 15 items that she identified here on the record today her priorities?
Are they different than her last priorities to us?
I do not know.
She could tell you that.
She would have to tell you that.
Are they different?
Not really all. The only ones that are added that are any different are very long ago approaching, like the copies of the public notices for any public hearings, which I presume exist. So I'm not trying to confirm it right.
The department has been working with Anne Marie all this time. Every day, every few days, we email her. We ask her what the next item is. We send her documents. We have been working with her all along.
Right. So if she were to identify these, I couldn't quite understand what the 15 were, but if she were to identify them to you tomorrow and say, here are the 15, and we would be in agreement that that priority would not be reworked, that would be the priority that you would go with. Right. And you could make that a commitment and get those documents produced on short order.
I don't know. They might be very extensive requests. Some of the requests really require hours of search from our staff.
I understand that.
I'm certainly we will work with whatever her next priorities are.
Could you at least give her a response? Let's assume that, this is sort of going back to square one, unfortunately. Mm-hmm. But if she gave you the list of the 15 items tomorrow, could you treat those as an immediate disclosure request? Give her at least a response, not necessarily the documents.
I certainly
give her
for each of the 15 items,
a response, just a response on each of the 15 items. Could you do that?
I'm not sure if I could. If you looked at her requests, they are confusing. Mm-hmm. They are very similar to one another. You have to really study them carefully to determine, how they differ from one another. Certainly I could respond to her email.
Okay.
for the request
Okay.
and say, yes, we have received your requests, and we will put them as your new priority.
Okay,
Yeah.
that's fine. Thank you.
You're welcome.
A final
Member Coughlin.
thing to pick up on what Mr. Chair Nee and Vice Chair Craven Green have said, Ms. Gong. Ms. Gong, we do appreciate that you have done a lot of work. Could you sit down with Ms. Mahbood? And we've had these cases before where there's really a lot of information that's been requested. I think that Ms. Mahbood feels that some of the materials could have been produced more quickly. Could you sit down with her and talk together and explain your issues to her and set out a timeline? You can have this one on September 15th. We can probably get these for you by September 15th. We can get these by September 7th. I think there's the implied rule of reason that you stated. I mean, I think that we really do have to work together when there's a large request to I mean, there are human capabilities on both sides that have limits. So are you willing to work with her and sit down and work out a schedule for production of these documents?
I cannot speak for, it's just not just me that are gathering these documents. It's, I have to ask other staff to gather the documents. So it's their staff time too. And, I can't speak for them really to say, you have to get these.
So how responsive has staff been?
They have been very responsive. It has been a huge amount of work for staff. Mm-hmm. It really has. It has been many, many hours.
Is there any way that you could communicate with staff that you've been here and when there has been a request that a timeline be created, and can they give you, like with the police department, they made their effort. Mm-hmm. They weren't sure how their index of records would be accepted by the next step up. But I mean, I think that what we would like is that to make sure that there is being given a fair shake on both sides to work together and try and get this sunshine request taken care of within a reasonable, as you say, time frame. That's all I would want.
Yeah, I mean, sure, yeah.
I mean,
we are totally open to reason.
So I mean, I think that Ms. Mahbood, are you agreeable to sitting down with her and working out some kind of
I've already done that on at least one occasion.
Please approach the microphone.
Well, I mean, you can stay up there, Ms. Gong. How about working with her? I mean, she's been here. We've all said the same thing, that the documents are public records. It's just a question of the capacity of the department and your capacity for patience and interaction with Ms. Gong. Ms. Gong, are you? I mean, I'm just hoping you two can work together, because it seems like the only way that's going to satisfy anything's going to happen is going to satisfy both of you within the realm of reason.
I think we've heard from they're both willing to work. They just have different opinions on how that might work. And what I would suggest is this for the members to consider, that we refer this issue to compliance and amendments, that we ask Ms. Mahbood to put in an email the top 15 items that are your priorities in their order of priority with descriptions. So not just exhibit items 2 and 5 from exhibit 1. Instead, spell it out.
I do that, but
CC that to the Compliance and Amendments Committee, or CC that to the Sunshine Ordinance Task Force. At the Compliance and Amendments Committee in 2 weeks, we will hear from you and from Ms. Gong as to what the status is on those 15, and we'll be able to hear, how much time was this one? Was this one really, is this 10 hours of time? Is 10 hours of time too much? Maybe 10 hours of time is what it is, and it should have been complied with. Mm-hmm. So if you can do that, identify those 15 items, email it to Ms. Gong, CC it to the task force, so that one's heard by the Compliance Amendments Committee in 2 weeks. We'll have a concrete idea of not only what was requested, but what they've done in that 2 weeks, so we can have a sense in how are they really responding. All right, is this on the back burner? Is this on a front burner for them? Can they do better? Can you be clearer? What are the issues? So, I mean, that's what I would suggest that we propose from the task force to have done as a way of moving this forward.
Is that a motion?
I think it's, if there's no order of determination, it's through the chair.
I would like to make a motion.
Proceed.
Under 6725, if the voluminous nature of the information requested, its location is in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 days as provided in Government Code Section 6456.1, the requester shall be notified as required by the close of the business on the business day following the request. In all fairness, we have cited giving orders of determinations against all other departments within the city. I think the best way to follow is to give an order of determination to find a violation and then refer it to CAC to see if it has been complied with.
Okay, is that a motion?
That's my motion.
Okay, to refer it to CAC with a finding of violations of which sections? 6725. Is there a second?
Second.
Moved and seconded.
I'm not sure I support that, because I think it sounds to me like they have responded to the media disclosure request. They just have said we need more time, by and large, at least for the initial 15 or 20. When after it was 15 or 20 and getting on to 30, it sounds like they were saying we're handling a request one at a time. It would probably have taken more administrative time to have responded than to have, stopped looking for documents. So, I do think there is a limit here. And so I don't think 6725 is necessarily the right. I just wouldn't support a finding under that section.
I'm in partial agreement with you, but only because, in fairness of our other rulings that we've given, if people don't have an index of records, or if they don't have the capacity, we have still found an order of determination against them. So
right, but maybe 6721, not 6725, is my point.
Would you make that motion?
Or I would ask maybe that your motion be 6721.
Then I will change it to 6721.
Second agrees.
Second agrees. Before we proceed further, we were going to give each side, the respondent first and then the complainant, 3 minutes each to make any concluding or rebutting remarks. Ms. Gong?
I just feel like the department has spent so many hours on responding to these requests, and that tomorrow we're going to get another 15 reprioritized lists that we will have to work on. And then what happens after that? Is that the end of her request, or then we move on to the next 100 requests? So it's very daunting from this point of view. And I don't see any light in the tunnel for our department regarding these requests. It just seems like we're being asked to spend many, 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 many hours responding to so many of these requests, and the requester is never satisfied. And tomorrow it's going to be another reprioritization, another many hours spent on these requests. And so I'm just saying it's very disappointing on this side.
Thank you. Ms. Mabott?
Okay, so let's just speak to item 34, which was a request that I had placed over a month ago, I believe now, for a copy of all requests for these permits in question. Olive, you've had this as the number one priority for over a week, and yes, I still don't have anything. And specifically, if you review the exhibits that I've given you, there's clearly been violations of 67.25D, timely and rolling responses. Yeah, and one of the items that I've marked as an exhibit and provided to you, on August 6th, I went to Julius Kahn Playground and observed one of my competitors who has one of these permits in violation. They had more kids than were allowed under the permit, and as such would have been required to play twice that amount. I immediately called Park Patrol, reported it, and waited till they came out there and spoke to the people. I said that those people should be issued a citation on the spot. They are not entitled to a warning. They clearly know the permit process and what is required. That incident report, I immediately requested later that day, a copy of any ticket that was issued, any warning, and any incident report. I haven't received anything from Park Patrol, which is a separate issue, but I submitted to the Permits and Reservation Office a copy of any permit extensions that were issued based on the complaint that I had made on Thursday, because I was informed by Park Patrol on the next day that soccer kids had requested and secured an extension on that permit. So I sunshined a copy of that extension as well as any receipt or invoice for the fees. This was just issued the day before. It was one document. On Tuesday, August 11th, I had still not received the document. So I went over to the Permits and Reservations Office myself, inquired of the individual employee who I had actually made the request to. He informed me that that day he had responded and printed up the responsive document and was getting ready to send it to me when he all of a sudden started receiving numerous emails saying that everything must go through Olive Gong. So I immediately left the log cabin, went back to McLaren Lodge, and when I picked up other documents that Olive already had available for me, I mentioned that I wanted a copy of this extension. She initially suggested that she did not have it available. It was on her computer. I stood there until she printed it out. So that in itself was clearly a violation of 67.25D. And I further insist that all sunshine of the sunshine requests that I have placed in accordance with 67, I believe it's .24. I'm not sure, but it's the sunshine of the sunshine requests. I forget the exact site. But it regards any communication of any kind regarding compliance with the Sunshine Ordinance. I've made numerous requests of that nature regarding a number of individuals, including Olive Gong, and I've essentially gotten a blanket denial of any documents. And I submit that those kind of requests should include any and all inquiries that were submitted to any employees or individuals who might have responsive documents and would include their responses thereto. That type of request would also include any correspondence between the Sunshine Ordinance Task Force and any individuals who are required to appear. And as I state, I received nothing. I received copies of 2 documents from the City Attorney's Office, apparently in response to
Could you please wrap up your remarks?
I'm sorry. So basically, I've not received any responses to my Sunshine of Sunshine requests either, even though clearly correspondence existed.
Thank you.
Thank you.
Matter is back with the committee. Is there further discussion? Seeing none, we have the roll call on the motion, please.
On the motion, Member Craven Green.
Aye.
Aye. Member Cawthon.
Pass.
Member Cawthon, aye. Member Washburn.
Member Costin passed.
Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu, excused. Member Cawthon.
No.
Member Cawthon, no. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 7 ayes and 1 no.
Thank you. Thank you both for coming. Thank you for your time. Mr. Clerk, would you call the next item, please?
Item 13 is the determination of jurisdiction on the complaint filed by Rita O'Flynn against the Mayor's Office of Housing for allegedly deleting email records which were the subject of a Sunshine Ordinance request for records.
Okay. Is there a motion?
I make a motion to find jurisdiction.
Second.
Moved and seconded. Is there public discussion on finding jurisdiction? Seeing none, public discussion is closed. Is there discussion among the task force? Okay. Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu, excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Okay, we are ready to proceed on the merits. Is the complainant present? Please approach the microphone. Thank you for coming. You have 5 minutes.
Hello again. My name is Rita O'Flynn. I'm going to just give a quick recap of what's been going on. My property at 1672, 1674 Great Highway was the subject of a HUD-sponsored lead abatement that was managed by the Mayor's Office of Housing. Upon completion of this, I requested to see the complete files for my property. I went to the site, I went to Mayor's Office of Housing, and had an opportunity to review the files. I asked for a complete copy of the files to be provided to me. I was informed that they were available about a week later. I stopped by to pick them up. I was told that before they could be released to me, Myrna Melgar-Eitan of the Mayor's Office of Housing wished to speak with me. I refused to speak with her. I was given the records, and a large number of the emails that I'd gotten to review on site were not available. I made another request of the Mayor's Office of Housing, and I was advised that the electronic copies had been the emails had been destroyed per their requirements, and that there were no other email. There were no other hard copies of the email, even though I just seen them a week or so ago. I attempted several times to try and resolve this with the Mayor's Office of Housing. I then realized that if these were in fact deleted emails, that perhaps I could get them from the Department of Technology. I applied in November of 2008 to get the records from the Department of Technology. The first week of December, I was informed that my records were ready for pickup on CD. My husband went the next day to go get them and was told he could not have them. We couldn't have them at all. After that, I filed a complaint with the Sunshine Ordinance Task Force regarding noncompliance. I think you guys found jurisdiction. It wound up going also to the Compliance and Amendment Committee. There was a lot of information given by the Department of Technology in terms of the incredible cost of retrieval, the cost of conversion of these records, the need then to redact information. I agree that that's probably not a cost that they should be bearing. It should go back to the Mayor's Office of Housing, whom I believe destroyed those records incorrectly when a Sunshine review was in place. In the meantime, I've discovered that right around the time I made my request of DIT for records, apparently, somehow, so did the Mayor's Office of Housing for their emails from several account people at the Mayor's Office of Housing to be restored and provided to them. And what I've heard so far is that I've got Mr. Fraser from DIT informed me on the 12th of August that DT did provide MOH with restored user accounts for some of their staff, including Myrna Melgar, in November or December of 2008. We were unable to find any written or electronic record of request or delivery. The request was most likely oral, to which I asked him to let me know, what time period, something, anything that he could tell me. And then I heard, I'm sorry, this is a little out of order, but yeah, they provided records to the Mayor's Office of Housing based on a requested time period. And again, but now I'm hearing we have no records. We know we gave them something, we know we gave them their email, but we have no record of it. I'm sorry, I can't believe how much trouble people are going to keep me from getting copies of emails that I've already read. That's it for me.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, you're here for the respondent, sir? Please approach. Thank you for coming. You have 5 minutes.
Thank you. I'm Oliver Hack. I'm the Chief Operating Officer of the Mayor's Office of Housing. The Mayor's Office of Housing believes that we've been fully responsive to the request to see emails. We don't know what emails she saw in the file. She was handed the file, apparently. And then when the copies were provided to her, she claims that those emails were gone. No one in our office took anything out of the file. The file still exists in total in our office, so we don't know what she's referring to. And as far as I understand, that's the substance of her complaint, that there were missing emails in the file. We don't know what emails she's referring to, and nothing, as far as we're concerned, has been removed from the file.
Okay.
Yeah.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
I have a question for the mayor's office. If the complainant were to make a request for emails regarding her property for that period, would you be able to retrieve them?
If they hadn't been deleted, yes.
But does DTIS still have them?
As far as I understand, and I'm not claiming to understand DTIS's record retention policies, but in what I have seen in their response to Ms. O'Flynn was that they keep a backup tape of every email that anyone in the city ever has written or received. But those are kept for disaster recovery purposes, and they are not. Their city attorney told them that that is not subject to the Sunshine Ordinance backup tapes. So if an email had been deleted, then I don't know if DTIS could or couldn't retrieve those, and if they could, whether or not anyone could just read them.
Ms. O'Flynn told us that this Ms. Melgar, I think that's the name,
Yeah.
had requested, he made her own request for certain emails. What's the status of those?
As far as I'm aware, no one in Mo has ever made a request to DTIS that they supply us with emails. And I'm not sure if this is the same request, but there was a request that Ms. O'Flynn made for 5 years of emails between various parties. We would have no reason to ask DTIS to give us those. So we never made a request to DTIS.
So if she asked you for those, you wouldn't ask them for those?
No. I don't think we would. We delete them. As far as we're concerned, they're deleted. What DTIS does is what DTIS does with them.
Thank you.
Mr. Hackham, a couple of questions. Ms. O'Flynn, maybe you would have the answer to the first one as well, one or the other of you. Were the email records deleted before or after the copies were requested?
I'm sorry, one more time?
Were the email records deleted before or after the copies of those emails were requested?
I don't know the answer to that question.
Ms. O'Flynn, do you happen to know? I do. Please approach.
Those emails were clearly deleted after my request. It all happened on the same day. I reviewed the file. I said I'd like copies of everything in this file. Came back about a week later, was told that I needed to speak with Myrna Melgar before I could get the files. I refused. The copies were given to me. I went home and started reviewing them and started to say, well, wait a minute, what happened to this communication? What happened to the communication regarding the child under the age of 6? What happened to the communication regarding relocation? What happened to all of these emails? They're not there. Again, I was told that they were destroyed electronically in compliance with their department record retention, and that there were no other email. At that point, I tried to re-request the email for my property. I was told, no, it's all been destroyed, we can't have it. So I made a more extensive request in an attempt to recreate and recapture that information.
How are you able to discern that the emails were destroyed after you requested them instead of before? I mean, you said you got records.
Paper copy right there in the file.
Okay.
I see the paper copy. I ask for copies of the file. I get them back. I open it up, I look, and I don't have those emails that I'd just seen the week before, and then I'm informed that they were also destroyed electronically.
Okay. Mr. Hackham.
Can I say something?
In a second. Do you happen to know if the emails were backed up before they were deleted from the system?
As far as I understand, DTIS has a copy of every email. It's not I don't know how their process of backing up happens. From what I just heard, she is alleging that we have destroyed hard copies of emails. And then somehow she's saying that from the moment we destroyed those, we went and destroyed the electronic copies. I don't know how she could know that. It doesn't really make sense to me, because she's saying that she saw hard copies of emails, and then she received copies of the files that did not have those hard copies of the emails, and then requested them again, and we said apparently that the electronic copies had been deleted. I don't know how you could determine that we deleted them in the moment that between requesting the hard copy and asking for the electronic copy. It doesn't make sense to me.
Member Crofton.
Mr. Hackett, is it Hackham? Sorry.
Hackett,
yeah.
H-A-C-K.
I wanted to point something out in the Sunshine Ordinance. There's a section 67.21, and section C does say that if somebody makes a request of you and you don't have it, but you do know where to get it, that you're supposed to let them know. That 67.21C? Yeah, C. So I just wanted to make that clear. So it would have been proper, I think, to let her know that DDIS would be a place for her to look.
I don't know. I wasn't even with Mo at that time, but apparently she did find out that DTIS was the place to look.
But
I don't know if we told her or she figured that out
Right.
herself.
But I mean, as I say, that is a duty of the custodian or whomever is asked for the record. So I just wanted to point that out.
And I'll add that I don't think we even knew that DTIS kept every email of every person on backup tape. Yeah.
Okay, thanks.
Member Craven.
I wanted to get some clarity from Ms. O'Flynn on the timeline and the names of the people she spoke with and when they told her, because it is very important, and we don't have the details in the record. I seem to recall in the prior complaint there was more detail, or at least in the prior complaint against CTIS, there was a little bit more of the timeline
Yes.
provided. So, and that's not in this one before us right now.
Okay.
So, you had requested all emails and correspondence related to your property?
After I had
This file that we're talking about.
This file.
What did you request and what was provided?
In the paper file, I requested everything from the paper file regarding my property and the HUD-led grant.
I'm sorry. How did they? Was this paper file just the file that they had on your property?
It's a regular file, manila folder.
I understand, but why? What I'm trying to find out is, were those documents gathered in response to a request from you?
No.
Or were those documents existing?
These documents were existing.
All right, so explain to me what this file was then, as far as you understand it.
These were existing files that were required to be maintained by HUD, because my property was addressed under a HUD-led grant and was funded through federal funding that was managed by the Mayor's Office of Housing. As such, they were required to keep these existing records and keep them for a certain period of time. I believe the city says that it has to be 5 years based on an owner's agreement. And so...
So what was the original request for then?
After I reviewed the existing hard file.
That's the very initial.
So when I realized that there were no that the emails weren't there.
No, before that, I want to know what was your original request to the Mayor's Office of Housing that led you to review that file.
That was my request, to review my file. That was my
The
first.
request said, I want to review what?
I want to review the file for my property as it pertains to this HUD-led abatement grant.
Okay, but you didn't ask for all documents or emails in the Mayor's Office of Housing at that point?
Not at that time, no.
Okay. All right. So, and then what date did you go in and look at that file, the paper file, approximate?
I think it was in May of 2007.
Okay. And so in May 2007, you reviewed the file and you saw, you allege, emails, correspondence about your property?
Yes.
Okay. And so then you asked for a copy of that file, and when was that copy provided?
About a week later.
And at that point, and this is to clarify, if I state anything that's incorrect, please correct me. At that point, you looked at the paper copy of the file that was made, and you thought that there were emails missing. Is that right?
I knew there were emails missing.
Okay, and then so what was your next step? What did you request next?
I requested the email. I requested to get copies of the email that had been in the existing file. And I sort of gave them, I don't even remember if I gave them an date range, but I was very specific to the file that had to do with the HUD grant and that I wanted them to provide me with some of the missing emails. I told them some of the names. I said, there's some correspondence clearly missing between Myrna Melgar and my tenant. It looked like there was some correspondence that had included some reference to Fiona Ma. All of this stuff was now conveniently missing.
Okay, and then what was the response to that request?
Mr. Shoemaker told me that I had all the documents responsive to my request and that emails had been destroyed in accordance with their policy. Electronic versions had been. Because let me take one step back here. In my request to have them send me the missing emails, I asked them first to just get me the hard copies as they originally said they would, and I said, and if you don't have them, please reprint them from your electronic files.
So Mr. Schumacher responded and said, you have all the documents responsive, any original emails have been destroyed. Did he indicate when those were destroyed?
No, he didn't exactly indicate when they were destroyed, but he says just the way he said it with our policy and the fact that the hard copies were suddenly missing, something's not right. And we're talking about emails that were less than a year old. And that's not part of their policy to destroy email that are less than a year old.
How old were the emails at the time?
There's probably emails from 2005, 2000, and 2006 and the beginning of 2007.
The ones from 2007 were the ones that were not.
No,
They were not less than a year old. Is my point.
Okay.
How do you know that those emails existed? Based on your review of the hard copy, is that the only source that you have for knowing those emails existed at some point?
That's the only source that I have for some of them. I do know that there was some correspondence that went back and forth between the Mayor's Office of Housing and my husband. Some of that was available when I reviewed the chart. However, afterwards, it was not there. But I can still get it off my husband's computer. So,
okay.
Yeah, I mean, I don't know how much more information you guys would need. I mean,
okay. That's just it. I mean, what we need is I'm not familiar if you're, familiar with courts of law, but we need evidence that emails existed other than just your word.
Okay.
I mean, evidence that they existed and that at some point they were deleted and they were not provided.
Yeah, and I can get those for you if you'd like.
So that's the evidence that you have, basically, is that your husband had sent emails about the property to the Mayor's Office of Housing, and when you requested first the hard copy file, they weren't in there, and then when you requested all emails, you were told that they were deleted at some point.
And then I had everything.
Okay, and so that's the evidence that we have, that there were emails that existed that have not been turned over.
Right. And just so you know, it's just the tip of the iceberg, the email.
One of the problems that I have, and I apologize, is because in the prior issue with DTIS, my understanding was that you were told that the emails had been deleted after you had requested them. And here it's not so clear that happened.
Okay, yeah. I mean, I was left with that impression as well, that had been deleted as part of some routine cleaning of the files. But I can't say for certain that those emails were not deleted before I reviewed the hard copies.
Right.
But even so, where are the hard copies?
Right, but we don't have any evidence that those exist other than your word. That's the problem that we have.
Okay.
You know what I mean? It's like
Yes.
there's no that's just the issue that we have. Is that you say that there were ones there, and Mr. Hack is saying that he doesn't believe that there were ones there, that they, as far as he knows, he wasn't there at the time, I take it, but that
Mr. Hack
emails
has
weren't
only
destroyed.
recently joined the Mayor's Office of
Right.
Housing. I'm not sure that he's aware of some of the things that have gone on. But again, we go right back to the fact that I put in a request for the materials from DIT. I'm told I can't have them. But yet I've got documentation that apparently the Mayor's Office of Housing requested them and was able to get them. And now you're saying there's no documentation of that either. So are you telling me that Myrna Melgar lied in a letter to me? In a letter? About getting this material?
Yeah, no, you have to, right, no, that's not appropriate.
Well, I mean,
unfortunately.
then obviously...
I'm sorry, we have to wait for a question to be asked. You'll have a time.
Please address your remarks to the task force.
Well, then I guess I've been lied to in that other document that Ms. Melgar generated, claiming that she got the records from the Department of Technology.
I'm sorry, what exactly did you're speaking in generalities that we can't follow. What exactly did Ms. Melgar say to you that she had received from DTIS? It's not in our packet, so we don't know.
Okay.
You see our problem?
Yes.
And so we need you to be very specific. Then Mr. Hack may be able to respond. But unless you're specific, we can't.
Okay. There's a letter from Myrna Melgar dated 19 December 2008 in which she states, I was provided with backups of my emails by the Department of Technology.
Okay.
That's a quote.
All right.
Again, that's the 19th. I've made my request in November. I then asked...
Why was Ms. Melgar telling you this, and what was the purpose of her disclosing this?
Because of the repeated requests for the information.
And what did she say she did with the backups? I mean, I'm sorry.
This is all I have from her. Quote, I was provided with backups of my emails by the Department of Information Technology, to which I then went back to the Department of Information Technology and said, please provide me with all the backup email provided to Melgar per her request, any and all charges from DIT to MOH for the retrieval of backup email and its conversion into a format Melgar could review, any and all communication between MOH and DIT regarding Melgar's backup. And then I get, let's see, the response that I get on Tuesday, August 4th is, Ms. O'Flynn, I'm still researching your request, but so far I've found no records of any written requests from the Mayor's Office of Housing for the backup email you reference. We are investigating whether any oral requests were made or fulfilled. If any backups were provided, they would have consisted of all restored user accounts for the time period requested.
All right, so my concern is that if Ms. Melgar has backups from DTIS that have been restored, that those could be searched for responsive documents. So, I mean, that's the question I have. What emails did she ask back from DT? What did she get? And have those been searched for some of the correspondence that Ms. O'Flynn is looking for, that Ms. O'Flynn believes were deleted?
I'm sorry. Can you ask the question again?
Sure. We have information from Ms. Melgar herself that she received backups from DT of her email in December of 2008. My question is, what time frames were those backups from? And did Ms. Melgar search those backup tapes, the backed up emails, to see if some of the documents that Ms. O'Flynn is looking for were located in those backups?
I don't know.
Okay, well, it's something that would be helpful for us to know, because that would, basically let us know whether or not the mayor's office is continuing to do an efficient and effective search for these documents.
Mr. Laurenti?
Yes, there was a little unclear to me as to what was evidence as far as what Ms. Melgar requested. Was that in the form of a communication from Ms. Melgar to Ms. O'Flynn?
Yes, it sounds like it was an email to Ms. O'Flynn.
It was in a form of written communication, a letter sent to someone else.
And you have a copy of that?
I don't have a copy of that with me. No, I do not. I'm sorry. I thought the last time I was here when I provided a large amount of information that things would just be redundant.
Member Cawthon?
I just wanted to ask you again, Ms. O'Flynn. You were reading from an email from Ms. Melgar saying that she did have what you were looking for in email form.
No, that's actually not what she says.
Oh.
She just sort of says that she's done the due diligence. She implies that she's done the due diligence of requesting all the records from DIT and going through them, and that she has nothing else responsive to my request.
Well, maybe I'm misunderstanding then, because I was out of the room for a minute, but I understood you to read something from someone in the department saying that you could come in and have the emails. Wasn't there somebody who sent you that originally?
There wasn't, that was the Department of Technology who
Uh-huh.
actually informed me by email in
Mhm.
December that
Uh-huh.
my request for backups from the Mayor's Office of Housing emails regarding my property were available for pickup, and then my husband went the next day and he was told no, we could not have them.
Right. Ms. Cotham, we've already gone over that in the last
So if I
complaint.
could just speak, please. You know what? Sometimes in these cases we don't have proof, and we're all not lawyers. Sometimes you just have to go with your gut or how you feel that something is coming across. I think that Mr. Hackett, while I think he's here in good faith and so forth, I don't think he has the real background to know what happened. I think I have faith in what Ms. O'Flynn said, so I'm going to vote on behalf of her and vote that there was a violation.
I just wanted to clarify about that email from DTIS, about the DISC. DTIS testified before the full commission and before the compliance amendments that what it was, they went ahead and did basically the backup draw of the time frame, gathered basically a data dump of a CD that had emails from the Mayor's Office of Housing for that time frame. Someone in DTIS mistakenly thought that they could produce that CD to Ms. O'Flynn, and then someone else said, no, you can't just produce that. There could be a whole slew of privileged information in there. You cannot produce it, and that's why the CD from DTIS was not produced to Ms. O'Flynn's husband.
So let me just
to clarify, so
ask
everyone's
a
on the same
clarifying
page.
question of both Ms. Craven and Ms. O'Flynn. So Ms. O'Flynn, you thought that the DTIS had the documents, but then when your husband went in, they said we don't have them after all?
They'd actually written me and told me that they'd transferred everything to a CD and that I
Right.
could come in and pick up the CD.
Okay. And I don't like to ask questions of a lawyer, but I will if she will permit. So what are you saying, that they didn't have it?
No, they said they had it.
Right.
But then they discovered they couldn't turn it over because it was a raw data dump of all of the emails of the Mayor's Office of Housing for a 5-year period, which could not simply be produced to a member of the public. They had to go through those and take out attorney-client and privileged information. They were tons of non-responsive documents. So this is all in the prior testimony. And this is really a side issue. But I just wanted to be clear that that was not... DTIS did draw the data from Lotus Notes and put it on a CD, and someone mistakenly told Ms. O'Flynn she could have it, but they couldn't produce it because it would have violated a number of laws to do so.
So did they tell you that there was any way they could extract the information you sought without compromising their own information?
No, they wanted they really wanted someone else to sit down and review all those and pull things out and do the redacting. They just said it was going to be...
But they never did it, right?
No.
Okay, I just have one thing to say. If we could rule in favor of Ms. Mabott in the last case, where it's really a voluminous situation and there was an enormous amount of work, obviously, on the part of the Rec Park Department, it seems to me this is this is inconsequential in comparison to that case, which had files like this. So, I'm just inclined to believe that the department could have gone through and sorted out the information that Ms. Mabott wanted, and the fact that they didn't doesn't mean that they are blame free.
Member Williams.
And members, before Member Goldman, I thought he was leaving. When we accept these complaints, we need to go really through this, because I can see Ms. Flynn standing up here getting really, really stressed out. And for her to be interrogated like this, and this is what I feel right now, she's been interrogated. I feel that we should go on and find in violation. Do you have the copy of the letter that they sent your husband?
The letter where Ms. Melgar makes the statement.
Yes.
I do have it, but not with me.
Okay, that's fine.
But
that's fine. That's all we need to know. I see you getting stressed out, and I don't want to get you no further.
My other concern is, though, that if we get a finding that says the Mayor's Office of Housing will need to go through these restored documents and make redactions and pull documents out, they've already done that with a hard copy file. I have no faith that they will do the right thing in terms of reviewing and redacting electronic files.
Mr. Laurenti.
Oh, I was just concerned that we're keeping focus as far as what is happening. This is the Mayor's Office of Housing complaint, and we're going into the area of DTIS. And I think that we're straying from the issue.
Thank you. Okay, at this time, we're going to. Have we had public comment yet? Have we had public comment yet on this? Okay, at this time we will take public comment.
I'd like to comment that the representative from the Mayor's Office of Housing has stated that he didn't know that it was the policy to back up the emails. He now knows that it is the policy. He also knows from the testimony here that there was apparently a request from someone else in his department to have those backups put on a CD, and that the CD was produced, but it was not given to the complainant. So we now know that that exists. Well, the question is what was done with it. Obviously, I would assume that if the Mayor's Office of Housing made a request to DTIS to do that, and they did it and had the CD, but then decided for whatever reason they couldn't turn it over to the complainant, that they would have either retained it or sent it to the person who requested it in the Mayor's Office of Housing. So it would be simple to go back to that person and say, did you request this? If you did you get it? And if we have it, let's produce it. And if not, why not request it again? If you did it once and you got it, there's obviously no question that you can do it again. So yes, if he didn't know that it was there and that he could get the backups, well, okay, that's fine. Now you know you can get the backups, request the backups, or at least request the copy that was already produced and get it. And if you can get it, then you can look through it, search for responses, and either give her the emails or simply say that we've reviewed all the appropriate records during that time frame and that there's nothing responsive. Either way, they're getting the answer, they're fulfilling their responsibility, and she's getting a clear answer. Now, I understand what she's saying, though, is she's saying that the day I walked in, I made a request for copies of all the documents, and all the documents I saw included a number of emails. And when I got what I got, there were no emails, or there were very few emails. So I really do believe what she's saying, and unfortunately what I'm hearing from the representative of the Mayor's office is basically I wasn't here, and I honestly really can't say. So if we need to go back to the person who was involved in the initial request, Ms. Magyar, whatever her name was, maybe that would be appropriate, and I would like to have him just simply offer to do that.
Thank you. Is there further public comment? Seeing none, public comment is closed. Member Craven?
There's a number of issues here. The first issue is, were there emails that should have been maintained that were destroyed? Right? And then there's the issue of, has the Mayor's Office of Housing done everything they can do to diligently search their email for responsive records, and whether or not that includes requesting backups, and whether or not they actually have requested backups and searched those backups. I don't find I have enough information from the department on either. I'm not sure when the emails were deleted that would cover the documents that Ms. O'Flynn requested. Were the 2005, 2006, 2007 emails deleted right around the time she requested? Was it only the prior 3 months emails? Or it's just unclear to me when that happened. And on the other hand, it's unclear as to whether or not Ms. Melgar, and I may be saying that name totally incorrectly, has in fact or did in fact request documents to be backed up from DTIS, whether or not those were provided to her, and whether or not those can be searched for these documents. So I really don't have enough information. I really feel like she's the person that we would need here to answer some of these questions. So I would be in favor of, unfortunately for Ms. O'Flynn, but to continue this to the next meeting and request her appearance. Ms. Melgar, Meljar.
Member Washburn, then Member Johnson.
Could we do something like this? Could we have the parties come to the Compliance and Amendments Committee? I'd like to see Ms. O'Flynn get these documents And then at our next meeting, look at whether or not there was a violation.
The problem is these documents don't exist. We had numerous hearings, the Compliance and Amendments Committee, allegedly. In order for DTIS to restore these is going to cost $8,000. It's going to take time to restore them, to put them in, to populate the certain mailboxes of the various members of the Mayor's Office of Housing who are involved, then to do the search, then to do the redaction, etc. So it's not as simple as that, as far as we know, unless these documents have already been restored, at least some of them, to Ms. Melgar's email or to the Mayor's Office of Housing more generally.
Member, did you have more?
I was just wondering if we could nail down that fact expeditiously about whether that CD could in fact be searched.
No. Now we're getting confused. The CD that was referenced had nothing to do with Ms. Melgar. Two separate issues. The CD that was referenced was made by a request from Ms. O'Flynn to DTIS directly, and DTIS produced a CD, which they couldn't produce for a number of reasons. Because it was just basically a data dump that had all sorts of privileged and non-relevant information. So it's separate. I think maybe what we can find out expeditiously is, did in fact Ms. Melgar receive from DT any kind of backup of her emails from the relevant periods in December 08, which is what Ms. O'Flynn seems to indicate happened. That is perhaps something we can find out expeditiously if there's an answer to from the Mayor's Office of Housing, from Ms. Melgar specifically.
Member Johnson?
I believe if Mrs. Flynn can produce a copy of that letter and the information from your husband's hard drive with those dates, that would help determine that.
Microphone, please.
Well, let me just ask this, actually. If my colleagues agree that we can continue this, what I would want are the following things. The original request to review the file and any supplement requests, if they were in writing. I understand that Sunshine Ordinance requests don't have to be in writing, but if they were in writing, the subsequent requests for review of the missing emails, so we can know the dates, so we can find out the dates of when those requests were made, and then the request for the backup of the electronic emails as well. That way, plus this letter indicating that Ms. Melgar had requested or received backup emails, we have the time frame, and then Ms. Melgar can tell us when, in fact, those emails from the different time periods might have been deleted. So, I mean, those are the parts of the information that we don't have, so we can't make a ruling, if you ask me.
Member Knebber?
I'd also like to add that I would like to see, or the original, the emails that she says she saw in the hard copy that she says were not there. What were they referencing? And if we can cross-reference that to Ms. Melgar's email, because I still think it's too wide. I mean, what were the issues? I heard something about a 6-year-old child there and such and such. I want that, instead of just being said, I wanted to see it, or especially if it was written back then. But I want those laid out to be able to see if we can cross-reference that to anything that we would get from Ms. Melgar or whatever.
I'm wondering if we have a 67.21E violation here. With all due respect for Mr. Hack, we appreciate your spending your time to come here, but you're obviously a newcomer, a relative newcomer, and there's a lot of information that we need that you don't have that Ms. Melgar does, and she, under 67.21E, should have been the one to represent the MOH. So if you'd like to comment on that, that's fine, but frankly, and with all due respect to you, you've been as helpful as you can. We appreciate that, but I really think that Ms. Melgar should be here.
Well, we asked for a continuation because she's on maternity leave.
I see. Okay. Thanks.
Yeah. I mean,
actually, that's an excellent point. I didn't know she was on maternity leave. When will she be back? Do you know?
I believe she's going to be back at the end of September, but that would be early.
Right.
I'm not exactly sure when she's going to come back.
Well, that might be an issue.
Okay. Then the 6721E is not relevant here. Ms. O'Flynn?
Mayor's Office of Housing has known about this meeting for quite some time. They've known what's required. They've known who should be here. They wait until Friday afternoon to contact Mr. Rostam to inform him that neither Ms. Melgar nor Mr. Shoemaker are going to be available. Is this a pregnancy that just sort of popped up out of nowhere? I mean, I think it's just incredibly inconsiderate to now step forward and claim that she's on maternity leave.
Excuse me, I have one question. Who is Ms. O'Flynn? Who
Member
is Mr.
Coughlin.
Shoemaker?
Mr. Shoemaker is the acting director of the Mayor's Office of Housing.
I see. Is there some, Mr. Hackett? Is there someone who could
Hack.
come and?
It's Hack, H-A-C-K.
Sorry. Is there someone who could come and tell us, in the absence of Ms. Melgar, who could give us more information?
Presumably, the director of MOH.
You think he would come? If we ask him to?
Of course he would.
We're
if he
trying.
could.
We've been spending.
I'm sorry?
We've been spending so much time on this.
I think that's totally inappropriate,
and the-
actually, what you just said, if he's not pregnant.
We apologize, sir.
Yeah, I'm sorry if anyone said anything that's offended you. That's certainly not my intention. I'm just trying to. We've gone on and on.
If Mr. Shoemaker is here on the next meeting, I'm sure he would be
Because
here.
I think it would be maybe a good idea. I just have faith in the fact that there's something behind. I'm a journalist, so I always think there's something behind it. And I just think that we really need to get to the bottom of this. And I know you're here in good faith. I know you're trying your very best to give us the information that we need. But I think it would be good if we could maybe continue it and get someone here who could give us the information that we need, and then we can sort this thing out. And I mean, you know, you were here when we had that Recreation and Park Department where there was a request this thick, and we, you know, we disposed of that, you know. 1, 2, 3. So I mean, I apologize to both of you for us spending so much time. You know, I don't think that our goal here is to grill people. We're trying to find the truth, but sometimes the truth is elusive. So if Mr. Shoemaker could help us find it, it would be great. Thank you.
Thank you. At this time, we will take closing, any concluding and rebutting remarks, first from the respondent and then from the complainant.
Well, I'll just conclude by saying that we'll do the best we can to figure out what's going on here, and we will go back. We will look again at the files. I had the file on my desk all day today, and we'll ask everyone to keep digging. And then hopefully at the next meeting we can resolve this.
Thank you very much. Ms. O'Flynn?
I, too, am hoping that this can be resolved. I think those emails are very important to me. I'm not sure why they were destroyed from the paper copies. I don't know why it's so impossible to get them electronically. I do want to say, though, I have no faith in the Mayor's Office of Housing to review those records, do the appropriate redactions, and provide them with me. I think there's an incredible bias going on. Thank you.
Thank you. There's been a motion. I'm sorry, Member Craven.
A motion to continue so that the complainant can provide all of the relevant original requests showing the dates that those requests were made, and that's a person with knowledge from the Mayor's Office of Housing can answer when the various emails would have been deleted, and B, whether or not Ms. Melgar or anyone else in the Mayor's Office of Housing has had DT provide backed up copies of emails, which may be able to be searched to provide the responsive documents to the extent they exist.
Second that.
Moved and seconded. Without objection? Continued. Thank you both for your attendance. Mr. Clerk, would you read the next item, please?
Item 17 is the determination of jurisdiction on the complaint filed by Peter Warfield against the public library.
What about 15 and 16?
15 and 16 have been withdrawn.
Withdrawn? Thanks.
Item 17 is determination of jurisdiction on the complaint filed by Peter Warfield against the public library for allegedly refusing to provide copies of a branch library's renovation plans.
Members, I move that we find jurisdiction on this.
Is moved and seconded. Public discussion on jurisdiction. Seeing none, public comment is closed. Discussion among the task force. Seeing none, vote please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Aye. Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. We're ready to move forward on the merits. Mr. Warfield, please approach the microphone. Thank you for coming and for bearing with us. You have 5 minutes.
Thank you. I'd like to ask the chair or the administrator through the chair whether there's going to be any explanation of the error that exists in the agenda packet.
Mr. Warfield, I think at this point it's best if we just proceed with the case.
Well, I'm sorry to be at the disadvantage of having to untangle a confusion that comes from an error which was not my fault. So let's start, and I also am regretting that it takes time for my case. So to start out with, let's look at page 326 to 327. That contains the library's denial of what had been previously promised, namely copies of some plans. Dear Mr. Warfield, and notice at the top it says, please include this as document number 2 in the library document denial complaint. So this was filed in the next complaint. I'm writing regarding your immediate disclosure and so on and so forth at the very top paragraph. These records are exempt from disclosure at this time for the reasons explained below. Now, previously, I had received a memo which is on page 319 and includes my memo from 320, in which I requested certain documents and they were initially provided. The basic issue here is that I requested I made a fairly simple request, and the request was initially granted, and then when I tried to get copies, and initially there was some difficulty, and then I was denied completely, not only the copies, but any access. So the request is contained in the August 21st letter that you received late from the library, and it's on page 3 of 7, and it looks like this, and I have said there, in a memo to Sue Blackman, I would like to see information about Park Branch Library renovation planning process as follows, and item 5, full set of plans and draft plans for the current renovation. I was then granted some access, requested that they make copies of 2 specific pages on 4 pages of 8.5 by 11. I guess they said they would try, then they came around and said they couldn't do it or wouldn't do it. So I said, fine, just give me the whole business. Just give me the whole 50% construction documents, which is a very large sheets. And on the 11th, they sent, as I described, the refusal. I believe this violates 67.21a, provision of documents. C, providing me with assistance as to where I could find what I wanted, even if the specific document was denied. 67.26, withholding must be kept to a minimum. They redacted the entire, they refused to even provide me with any page whatsoever, including the marginal notes, which in fact had led to a very significant discovery, which had nothing to do with the specific plans, but the stage at which the library had found itself. And to briefly describe that from the original that I saw, I realized that when the library provided its very first look at plans for the public at the branch in January, supposedly to solicit comments and input, they had in fact completed 100% detailed design and 50% construction documents prior to that very meeting. And I learned that from a marginal note in the 50% CD that had nothing to do with any specifics about the plan. And 67.25I says the public interest may not be used to justify a withholding, and I'd be glad to read that to you. The information should have been provided. Actually, the original copies that I requested on 4 sheets of paper from the large sheet, I think could have and should have been provided. In refusing to provide information completely on the 50% CD, assistance should have been provided to get alternative plans, and withholding should have been kept to a minimum. The same or similar documents were in fact provided to the public at 2 meetings in January, several months earlier, and I have a picture of those if you want to see. They provided me with nothing, and they were very generous with providing copies of documents when and views of documents when, for example, the public was to be sold something about that plan, but when I asked, I was to get nothing at all and no assistance for any even alternate documents whatsoever. So I think this is a really serious violation of sunshine on multiple levels, and you should find the library administration in violation of the sections that I have mentioned. And I'd be glad to answer any questions. The kind of surprising and unexpected, and I think an appropriate thing, is that the section that the library has used in its letter to justify the denial is actually from a section of sunshine that's intended to expand denial, and that is section 67.24A1. No preliminary draft or department memorandum, whether printed or electronic, shall be exempt from disclosure under such and so on. Only the recommendation of the author may in such circumstances be withheld as exempt, and I would suggest that 50% construction documents don't qualify for any kind of an exemption under 67.24.
Thank you, Mr. Warfield.
Thanks very much.
Is there anybody here to present facts and evidence in support of the complainant? Seeing none, respondent? Thank you for coming. You have 5 minutes.
Thank you. Sue Blackman, custodian of records for the library. First of all, I want to apologize for our late response to this. There was some confusion as to the complaint. I received 2 complaints on the same day, and they were very similar. I assumed that it was the same complaint sent twice. So I want to apologize for that. We did rush to get a response out and to you on Friday, so it's included in your package. Mr. Warfield referred to both his request of March 2nd, which included a considerable amount of information he was requesting. In an effort to provide that information as much as we could in a timely manner, we did make those construction documents available because they were in the library's possession. Later, when Mr. Warfield asked for the copies of the construction documents, we were informed by DPW's attorney that those were not eligible to be made public. So it was the library's mistake in making them available to begin with. In our effort to make a timely response, when we found out that they were not eligible to be made available because of the competition and they weren't out for bid yet, and once they were out for bid, they would be available to the public or anybody who's willing to bid on the project. So basically, his exhibits are the same as our exhibits with the same response letter of March 11th.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Craven Green.
I wanted to ask Ms. Blackman, Mr. Warfield referenced copies of plans for this branch library that were shown to members of the public in January. What copies were provided to members of the public in January?
We provided Mr. Warfield everything that had been made public prior to, as part of the response, and I don't have that response, but everything that he had requested in his request of March 2nd was responded to. We did provide him with a peer review response and all the information that was provided to the Library Commission.
Well, let me ask separately. Were copies of the 50% construction plans made available to members of the public
No.
in January?
No, not. I mean, there were not copies available. They may have had portions or documents or something. I'm not sure exactly what was presented at any public meeting, and I'm not sure what documents he's referring to. I mean, we provided him with everything.
I understand, but my question is specific.
Mhm.
Were the 50% construction documents or any subset or portion thereof presented to the public in meetings in January?
Not as far as I know. And if there was a document, it was anything that we
All right,
had
well, the answer is you don't know.
provided for him.
You don't know whether or not the 50% construction documents or any portion thereof were provided to members of the public in January.
Well, what I'm saying is if something was provided at a meeting that I was not at, it was also provided to Mr. Warfield in response to this.
Right, but I mean, the question is, that doesn't help me. That doesn't help me. Because if, in fact, the 50% construction documents were disclosed in a public meeting, then, basically under California PRA, there's been essentially a waiver, and they can't be withheld. There's arguably been a waiver because they were disclosed to Mr. Warfield in the first instance. But I'm trying to figure out if they were broadly disseminated, as how
No.
some cases decided.
They were not.
If they were shown to members of the public.
As far as I know, no,
Okay.
they were not.
All right. Mr. Warfield, you mentioned that something was shown. Do you have any knowledge that these specific documents, the 50% construction documents that you were shown but not provided copies of, were they produced or shown to members of the public at the January meetings?
At the January meeting, I have a photograph of what I was particularly looking for, very focusedly, as well as whatever other information I could get. The library, in my view, was essentially hiding as firmly as it could.
You're not answering my question, sir.
Okay. There was a diagram shown of the staff workroom that the library planned to insert in a beautiful open-spaced floor at the Park branch. And I never got this in response to this request, which I can give you copies of. I've made copies. The request did not ask for 50% construction documents. On March 2nd, the request was
That's not my
for
question, sir.
plans
Thank
and
you.
draft plans for the
Mr.
current
Warfield. Just the question here.
Okay, so they showed the public a document which I can pass around that had a drawing from two
architectural
perspectives of the closed staff workroom that is a very serious issue with respect to that otherwise open space.
Okay, and so when you went in to look at the 50% construction documents, was that page of that plan in that document, as you recall?
Absolutely. Now, there may have been, I don't know if there were more details provided, but the picture looked to me exactly the same, and that was one of the two pages that I specifically asked initially, which is in the library's material that they sent late. That is specifically, well, it's in my exhibit, and I initially just wanted 2 pages, one of them including this staff workroom picture.
Okay.
But
All right,
remember,
thank you.
I didn't ask for the 50%. I asked for general plans, and then they said they have 50%.
I
to show me.
understand that. The issue here, though, is whether or not they need to produce, everything has been produced except for the 50% construction document drawings, is my understanding. And so that's what we're dealing with today. Is that your understanding? The only thing withheld are the actual architectural blueprints for the 50% construction drawings?
No.
Okay.
The issue is that I asked here in a single line as item 5, and I'd be glad to pass it around. I started out, I would like to see information about Park Branch Library renovation planning process as follows. And then item 5 said, full set of plans and draft plans for the current renovation. I didn't know what they had. I wasn't sure what they had. I know that I had seen this material, and so when they then provided 50%, I say they should have, when they denied it, should have said, okay, we can't give you 50%, but we can give you this, which was shown 2 months ago at the Park
public
branch.
meeting. I agree. But the issue that we're dealing with today, as far as you know, have they produced all responsive documents except for the 50% of construction documents?
Only the 50% construction documents are specifically at issue, and I can tell you something else about to
So
whom.
that's just answer my question. At issue, the only documents that have been withheld and not produced in response to your request are the 50% construction documents. Is that accurate?
They didn't provide me with the document that I saw at the branch
Which
as
we
a
believe,
substitute,
right.
which could have been 50% CD or something else. I don't know. I'm not
Thank you.
familiar with the whole process. Thanks.
Thank you. This is interesting. I mean, I've never seen a case about architectural drawings being withheld pursuant to the section of the ordinance that protects drafts, and I don't think the drafts really apply. Basically, 6724A1 was passed to make it clear, unlike state law, drafts should be produced. Now, if those drafts fall into an exception, that exception being the department doesn't normally keep those sorts of drafts, then you might be able to withhold a recommendation. And basically what that is, here's a draft of a policy, and I've written on it my recommendation. I don't like this draft policy. We need to change it. Like that text, if you will, can be withheld, but the document itself has to be produced. So even if the draft or the 50% construction documents were not produced, or were not maintained after they were revised, even if they were not kept as an archived item by DPW or the library, whoever keeps the plans, still they exist now and they would have to be produced. So there's really nothing in that document that would be exempt, even if they weren't normally kept in the normal course of business, which we don't have any evidence of. So to me, that doesn't apply. The competitive bidding aspect is a little bit more interesting, but what the competitive bidding documents usually are applied to are the submission packets. Once document goes out, here's our RFP. Once that goes out, there's a cloak of secrecy, if you will, about the correspondence between the city and the bidders, so that the city can get the best deal. And the California Supreme Court 2 years ago recently affirmed that no, you don't get any of those documents released until the bid has been awarded. But that doesn't apply to the packet itself, to the information, the drafts of the packet that the city is sending out. That is a different category. That's the city's information showing what the city is thinking of bidding for. That doesn't really affect your bidding process. Your bidding process is what it is. The fact that we took out a staff room, for example, doesn't affect what someone's going to bid on the final project without the staff room. So I really don't see a justification for withholding these documents, either on 6724A1, which doesn't apply on its face, or under the competitive bidding provisions, or the California Supreme Court's recent case. It doesn't seem to implicate the issues that court recognized. So I think these documents should be produced.
Member Coughlin?
I would agree. I mean, that's what I zeroed in on. I just wanted to ask Mr. Warfield one question. And were these documents shown at the Park Library meeting that I was at, the one that Joey Kane called, the special one? The one that was held in the basement of the library?
There were two that were held very closely together. Was that the one where Joey Kane and I were presenting, and the library had the president of the commission and the branch manager?
Were those 50% documents up there on the wall?
I don't think so, but I don't know for sure.
But I mean, 50% documents are, what is it? They show 50% of what they're going to do?
I believe that that's a translation of detailed design into instructions for actual construction, but I am by no means an expert. This is one of the unfortunate things. The library has kept the public greatly in the dark about what the sequence is of the documents and where the approvals lie and so on.
I tend to agree with Ms. Craven. I just wanted to get some background from you, so thank you
So I
very
don't
much.
know if the staff workroom was or was not shown at the March 16th, I believe, or maybe
That
12th.
little thing that you held up when you first testified, that's the those are the documents that you're, what is that?
What I showed as a photograph snapshot was what I made a picture of at the January 22nd meeting that the library held for the public as its first public meeting where it was taking input supposedly for...
They had the designs up on the wall behind the podium.
Well, this one was actually on the floor beneath some other things on a stand, and actually was on page 2. As far as I was concerned, this was not really disclosing to the public about the staff workroom.
Okay, thanks.
But I saw it nonetheless by lifting it up and on my hands and knees, making a picture.
Okay. I certainly think that the code section cited by Ms. Craven would apply here. So
Okay.
I would be inclined to find violation.
Is there public comment on this matter?
As I understand it, the whole purpose of the Sunshine Ordinance is to get public comment on public matters. And if what they're saying is we're making plans to do something with the library, but we can't let anybody see because we haven't put them out for bid yet, well, once they put them out for bid, it's too late. So bottom line is if at any time they've made them available or if they have them now available, I agree that they're disclosable so that the public can look at them. And as Mr. Warfield obviously is a very concerned citizen as regards to library issues, he would be wanting to see those so he could make appropriate comments at public hearings and meetings. And withholding them would be a violation of his rights to do so.
Thank you. Is there further public comment? Okay, seeing none at this time, the respondent and then the complainant will have 3 minutes each to make any concluding or rebutting remarks.
Thank you. I just want to again refer to our letter of March 11th and the disclosure of these documents and undermining the integrity of the city's competitive bidding process. We are not in the bidding process yet. Disclosure of these documents prior to the start of the bidding process could create a competitive advantage for certain bidders. We recognize that Mr. Warfield is not a bidder on the project, but if certain contractors or people were interested in coming in and seeing these ahead of the time that they were made available as part of the bid package, it would give them an advantage in that process, and we want to maintain that bid process.
Thank you. Mr. Warfield?
Thank you, and thank you to the members for your questions. Section 67.24I, if I can find it, does not allow the kind of argument being made about the bidding process as I see it. It says, neither the city nor any office, employee, or agent thereof may assert an exemption for withholding of any document or information based on a finding or showing that the public interest in withholding the information outweighs the public interest in disclosure. All withholdings of documents or information must be based on an express provision of this ordinance providing for withholding of the specific type of information in question, or on an express and specific exemption provided by California Public Records Act that is not forbidden by this ordinance. So I don't think that, however you may or may not buy the argument about bidding, I don't buy it. I have to say that I appreciate where it's gone so far. Ms. Craven, I think, said that she would argue there had already been an exemption made by allowing me to look at it in the first place. I have a memo from the Branch Library Improvement Program from the manager of that, Lena Chen, subject Park Branch Library, 50% construction documents submittal. These documents were submitted in January. The very documents that I am being denied were being sent directly to Elena Engel, Friends of SFPL, 391 Grove Street, with an invitation to review the 50% CD submittal with your respective staff and to come to a multidiscipline stakeholders meeting Friday, January something or another at 3:15. 2 months before I requested this and before even the public had any chance to see anything of a picture or anything else. And I have a few copies here. I think there are only 6 or 7, but I'd be glad to pass those to you. I think you've already made a good decision and an inclination, but this, I think, nails it. I am to be denied the documents. The friends 2 months earlier are sent to them, Mr. Rustum, are sent them with invitations for advance review and comment and a meeting to discuss them as well.
Thank you, Mr. Warfield. The matters with the task force, is there a motion?
Yes.
I've moved to find a violation of 6721 for failure to produce public copies of public records.
Second.
Moved and seconded. Discussion? Seeing none, roll call, please.
On the motion, Member Craveney.
Aye.
Member Craveney, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excuse. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Yes.
Member Williams, aye. Member Chu. Member Chu, excuse. Member Nee.
Aye.
Mr. Chair, we have 8 ayes.
Okay. The matter will go from here to the Compliance and Amendments Committee. At this time, the chair will declare another 10-minute recess. We are back in session. Mr. Clerk, could you call the next item, please?
The next item is the determination of jurisdiction on the complaint filed by Peter Warfield against the Board of Appeals
Thank
for
you.
allegedly redacted information.
Thank you. Is there a motion on jurisdiction?
So moved.
Chair will second. Roll call. Is there public comment on jurisdiction? Seeing none, roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excuse. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu, excuse. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Okay, we're ready to proceed on the merits. Mr. Warfield, you have 5 minutes, please. Thank you again for bearing with us.
Thank you. If I might get a 1-minute warning, I'd appreciate that. Is that possible?
Mr. Rustum, could you, is that possible to give Mr. Warfield a 1-minute warning?
Sure.
Okay, thank you. Please proceed.
Thanks very much, Mr. Chair. Basically, this has to do with the Board of Appeals providing me with redacted documents from their so-called docket, which is to say their file of information and material related to an appeal of a demolition permit. The library wants to demolish the Ortega branch rather than renovate it, and some historical preservation folks and various others were concerned about it. Inga Horton filed a formal appeal of the demolition permit, and I was seeking information about what was in the file, in particular about who was in support and who was opposed. All those letters were in that file. So the story basically, on July 30th, 2009, just recently, I paid my first visit to the Board of Appeals to drop off a letter from Library Users Association supporting Inga Horton's appeal of the Ortega Branch Library demolition permit. I also inspected the file without critique of my inspection and requested a few copies of support and opposition letters, I believe, which I received the next day without redaction. On my second visit to review the file on August 3rd, Monday before the Wednesday meeting, I was informed by staff that new rules had been instituted. Contact information was to be redacted from any copies. plus names of individuals, as well as even organizational affiliation. There was no written procedure for this, and I was told that the new rules had been orally communicated by the director, Cynthia Goldstein, at a staff meeting the very day after my first visit. The previous unrestricted rules on copying and note-taking while one is reviewing material, I understood had been in effect for at least a decade prior. I asked for the director to give me a call, which she did the next day. That is the subject of a separate complaint, which is coming next. But when I came then to the Board of Appeals again on Wednesday, the day of the hearing, August 5th, I was allowed to review the material while a member of the staff sat directly opposite me at a table watching my every move and sharply questioned me at one point saying, are you writing down names? And I said, I'm not. But it very much interfered, I think, with my taking the notes, because there was not only a hostile note, but unclarity about what the procedures are. I was actually trying to make a count at least. And there was concern on my part, would my notes, which I needed to make public comment at the hearing later that day, would those be seized? Would they be reviewed? Would there be further questions? And so on. And I think that's very disruptive to a review and preparation of testimony. And certainly a violation of 6721, which is rendered increasingly meaningless when provided in a hostile environment. And I also think that the employee was coached and told not to, to basically interfere with my review. Thank you. As I note in my letter to this body, which is in the file. So I think that the relevant sections are basically that the documents have to be provided, and if there is redaction, there has to be minimal redaction in particular with specific justification of withholding provided in writing, which wasn't provided. And 6722E, public employees shall not be discouraged from or disciplined for disclosing any information that is public information or a public record. So in brief, their argument is that people can testify anonymously. Certainly they can, but they can also send anonymous letters. There was differential application. I was told Inga Horton and the library could have full access and full copies, and address and phone number are not personal information, they're contact information, and nothing the city let's leave it at that. Thank you very much.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you for coming and for bearing with us this evening. You have 5 minutes.
Thank you. My name is Cynthia Goldstein, and I am the Executive Director of the Board of Appeals. I'm the relatively new Executive Director of the Board of Appeals, which is a quasi-judicial body, as many of you may already know, that processes, hears, and decides appeals of a variety of different types of departmental decisions. Mr. Warfield came to our offices just a few hours before the appeal hearing in this case regarding the Ortega Branch Library. And even though we could have told him that there was not time for him to review the file, that he needed to come back another day, or even though we could have said, even under an Immediate Disclosure Act request, that he would need to at least come back the next day and we could prepare the file for his review. We realized that this was his one opportunity to really have a chance to argue his opinion before the Board of Appeals, because it was going to hear the case in a few hours. So I don't know what it's like for your staff before one of these evenings, but I know in my office it's quite busy as we prepare for one of our board hearings. It was just a few hours before our hearing, but we accommodated Mr. Warfield in order to allow him an opportunity to look at the materials. He does, we agree that we should have given him a reason for why we withheld the information that we withheld. Under the conditions that we were in, the time pressure to get ready for this meeting, We didn't do it then, and we never got a written request for that. In fact, the first time we got a request was in this complaint. In response to the complaint, we certainly have provided him with that reason now. We do not agree that he's entitled to inspect the records unredacted. The names of persons submitting testimony to the board are exempt from disclosure under public meeting laws. We are a quasi-judicial body, as I mentioned, and written testimony is a form of public testimony. In fact, as Chair Nee mentioned earlier, he acknowledged that people are not required to state their names when they come here to testify before you. The Board of Appeals feels the same way, that people are not required to identify themselves. They should be given the opportunity to testify anonymously. We feel that is written into the Sunshine Ordinance and the Brown Act, and that even though someone's testifying in writing, that they don't have to waive their anonymity simply because they're unable to come to the board. In fact, we find that a lot of times people who are unable to come to the board and speak orally, because we meet late into the night like this, are people perhaps who have child care issues, maybe have elder care issues, physical limitations, or disabilities of their own, people who are, can't make it to the meetings. And we feel that it would be discriminatory to treat them differently than we do the people who come to our offices. And finally, with respect to the addresses and home phone numbers, even your own website says that some of that information, that the home phone numbers are confidential, and we're just trying to protect the privacy rights of the members of the public. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Ms. Goldstein, could you approach the microphone, please? First of all, thank you for belatedly, though it was, providing the written justification for withholding. However, one question I have, and that is the people whose personal information was redacted, did they request anonymity?
There was no request submitted, no.
Okay. And the reason I ask that is, when it comes to giving out that kind of information, yes, people have the right of anonymity. But in a proceeding like this, the task force has consistently found that unless anonymity is specifically requested, the information personal information is not to be redacted. These people are there because they are doing business with the city, or they want to air their opinions with the city, or offer their insights and give information and so forth. And unless, unless it's applied very narrowly, the anonymity is. The anonymity is it's a non-factor. That's what we've consistently found. How the task force will rule this evening, I'm not going to predict, but that's the position we've consistently taken in the past. At this time, we will open. We'll ask for public comment.
This will be rather brief. Right here, I have some notes. I went down to the Rent Stabilization Board prior to coming to this meeting, and I wanted to look over a petition. I gave them a petition number. They took out all the documents. They took my driver's license and kept it as hostage. But then they let me go over to a little table in the public area. I sat down and I went through all the documents. I made notes that I wanted to make. Nobody looked at me. Nobody questioned it. They just provided the documents, and I think that's the way it ought to be in every public office. If they have issues about something that they feel cannot be, then they need to address those issues and say, I can give you this and this and this, but I can't give you that, and here's the reason why. And apparently in this issue, or in this area, it wasn't. And I also know that from a number of times of viewing the Library Association, et cetera, unfortunately, Mr. Warfield is kind of like I am with the city attorney's office. They don't like him because he goes in and says, I would like something, and then when they say, no, you can't have it, insists on getting it, and as a result, it becomes, all requests. It was like the lady in the previous one, she said, I made all my requests individual immediate disclosure requests, because if I don't, then what they do is they take the 10 days and then they ask for the extension every time. And it could be one page, and that's what they'll do. So the bottom line is you get to, they play the game and you have to kind of play the game on the other side. And I think Mr. Warfield should have been left alone, let him look at it. And if it was an issue that they couldn't give it to him because they were preparing, they should have very clearly said that to him and said, we can give you a copy tomorrow, which would have met the requirements, but they attempted to do, I think, kind of an end run, which is, I'll let you look at it, but you can't take any notes, and you don't copy down anything. And as the chair has already mentioned, if I send a letter and I put information that is confidential, and I specifically say, here's the letter, I should probably expect it to be released to anybody that wants to look at it as a public record. And if I don't want it, I don't put it in.
Thank you. Any further public comment? Seeing none, public comment is closed at this time. The respondent and then the complainant will each get 3 minutes to provide any concluding or rebutting remarks. Ms. Goldstein?
Thank you. I think what I'd like to add is that I am new director there. This is a new policy. This was done as a result of really the first time that the issue came up under my tenure. And staff had been adjusting to this new policy, and I had asked them to sit with Mr. Warfield to make sure that the policy was adhered to, especially because, as I mentioned, there wasn't time for us to do the redacting that I thought appropriate before he sat there and reviewed the file. So if he felt pressured or uncomfortable with the person sitting there, my sense is it might be because he was running out of time before the hearing and we needed to leave with the files to get to City Hall, and not because anyone was really interfering with his ability to spend the time that he had left to look at the file. Thank you.
Thank you. Mr. Warfield?
Thank you very much. I think that the documents should not have been withheld or redacted. The argument that people might want privacy, I think it's certainly up to them to express an opinion. I think the chair has made a comment about that. They could certainly send an anonymous letter. They could send a blank sheet with no return address, and it would get to the Board of Appeals, and it would be completely anonymous. Or they could label it confidential in some fashion, for example, at the top. It's routine on letters that people say confidential, or please, I'm afraid, so-and-so is going to come after me with a baseball bat, so please don't release my name. None of that existed. And in fact, the letters that I was particularly interested in were the letters that came from such organizations as San Francisco Architectural Heritage, or DACA-MOMO, or the Preservation Consortium. These are organizations that have weighed in on this matter. Certainly in the file, the first two I mentioned were there. And I just can't conceive that San Francisco Architectural Heritage, which in fact I had gotten a copy of my first day without redaction, and know what they're doing. I mean, they published my article about preservation on Park Branch. They're concerned about these other branches. They have no secrecy. In fact, they would love it if people would say, oh, great, how do I join a good organization that is doing good work here? So the idea that there's some automatic sense of privacy about people sending stuff to a public body, I think is just simply wrong. There was no explanation provided with the redactions. If, in fact, there had been an attorney consulted on the 31st of July, why on August 5th was there still no procedure, no written explanation, no guidelines as to what was supposed to be happening, and for that matter, no simple explanation, which presumably under attorney's advice could have been worked up in the nearly 1 week since I had first appeared and they had consulted an attorney. So I think that these arguments are not valid. I think that the ordinance is clear, and I hope that you will find a violation in order that these documents be provided to me. Unfortunately, the hearing has already happened, and I was not able to make the kind of public comment that I would have liked with solid backing and be able to say essentially every person and group with architectural background or architectural preservation background who wrote to the Board of Appeals supported renovating the library and preserving it. And none of people with a background like that, nobody with a background like that, favored the demolition. And I was unable to make a really substantive statement at a really important hearing because these documents were denied to me, as well as freely inspecting them without being challenged and interrupted while taking notes. Thank you.
Thank you. The matter is back with the task force. Okay. I have some comments I'd like to make. First of all, in her letter, Ms. Goldstein acknowledges, or I guess maybe it was Mr. Warfield, let me see. Okay. In her letter of August 20th to the task force, Ms. Goldstein says, the board allowed Mr. Warfield to inspect an unredacted copy of the file on condition that he not copy or take notes concerning information in the file exempt from disclosure by privacy or other applicable public meeting laws. Once Mr. Warfield or any other member of the public is allowed to see the records unredacted, all those records in their entirety, under the law, under both Sunshine and the California Public Records Act, are thereafter public. So the redaction in this case was, as I see it, improper. 67.1G, under findings and purpose, private entities and individuals and employees, private entities and individuals and employees and officials of the city and county of San Francisco have rights to privacy that must be respected. However, when a person or entity is before a policy body or passive meeting body, that person and the public has the right to an open and public process. So again, here was a matter that was before the Board of Zoning Appeals, and everything was out there in the public domain. Especially since, as Ms. Goldstein said, nobody requested anonymity, nobody requested any redaction of personal information. I'm trying to look at, I think there was a violation here. I'm not sure which section or sections. I believe 67.1G is relevant. And please bear with me. I believe 67.21 is relevant. And I think that's where it stops. 67.1G and 67.21. Do I hear a motion?
Move that we find the Board of Appeals in violation for in violation of the Sunshine or 67.1G and 67.21 A and B. I would say A and B. I don't know if those are the right ones that Mr. Nee thinks are the important ones. But B is withholding, or get justification for withholding. I mean, what does it say? Yeah, justify withholding. And
Justification was tardy.
26, justification is 67.26, I think, but it's also stated in 67.21B.
Second.
Justify withholding in writing.
Second that.
But 67.21 is enough. It's getting late.
Okay. 67G and 6721 moved and seconded. Is there discussion? Member Craven Green.
Yeah, I'm not particularly persuaded by the failure to provide justification in writing. I think, this was an oral request. I mean, it just seems to me like this was a request to do the document. The document was provided. They had a new policy. They instituted it. It didn't seem to me there was a real... The way it flows was not your normal situation where you would say, I want these documents, and they would respond and say, we're going to give these documents, we're going to withhold these. It was provided on the spot. And so I really don't think, maybe the justification should have been provided, but I don't really see that as a good grounds for a violation. But I do think that consistently this task force has found that names and addresses and identifying information of individuals submitting information to public agencies where there hasn't been a request for anonymity and where there's no concern about whistleblower or some other kind of situation where someone could be subject to harassment because they submitted information or participated in a public meeting, that in absence of those two factors, that the information should be public. And to be consistent, I agree that we have to hold that as well in this case.
Okay, so are you suggesting that we point to specific parts of 67.21?
No, I was just expressing, I remember Cawthon mentioned the failure to provide written justification.
I'm fine with doing 67.21 alone.
Okay. Further discussion? Roll call, please. Excuse me,
Can I have
member.
clarification of what it's 67.1G and 67.21 together?
Together, yeah.
Okay.
Roll call, please.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Could you read the next item, please?
The next item is the determination of jurisdiction on the complaint filed by Peter Warfield against the Board of Appeals for allegedly withholding information.
I move that we find jurisdiction on this item, members.
Second.
Moved and seconded. Is there public comment on jurisdiction? Excuse me.
May I speak under public comment?
No.
Okay. Regarding jurisdiction?
Since you are the respondent, are you contesting jurisdiction?
Yes.
Oh, okay. In that case, I wish I had known earlier. Please be seated, Mr. Warfield. Jurisdiction is being contested. You have 5 minutes to defend jurisdiction. Would all cell phone ringers please be turned off immediately?
Yes. In deference to the respondent, I think the concern was the timing, or a major concern was timing, and I thought I saw something in the letter about a jurisdiction hearing in September, and now this being a hearing. I do think that there's clear jurisdiction here, and without any question. My letter mentions violations of 67.20, 21, and 22. The issues involve the refusal to provide what I would say certainly is oral information, oral public information, and those issues are mentioned in those sections as I've described. So without going into the case, those are the issues that I have raised with respect to the actions under discussion, and I think it's very clear that those the failure to provide requested oral information is an issue that Sunshine clearly covers in the sections that I described and possibly more. And if I haven't, I wasn't really prepared to make this discussion, but if I would be very happy to answer any questions should anybody have any.
Thank you.
Thank you.
Is there anybody here to present facts and evidence in support of the complainant on jurisdiction? Seeing none, Ms. Goldstein, please approach.
I just have a procedural question since I've been out of the office for 2 weeks. Did the Board of Appeals challenge jurisdiction? Usually in that process, if they do challenge, usually goes to the complaint committee to hear. So.
Okay. Ms. Goldstein,
Let me
please
just
proceed.
to clarify, the date we were given to challenge jurisdiction was September 8th, and the date for the hearing on the merits was tonight. So we didn't really have an opportunity to challenge jurisdiction before this evening's hearing. And that's why I wanted an opportunity. I appreciate you giving it to me this evening. Very briefly, I don't disagree that oral communications could be subject to sunshine review, but the oral communication that Mr. Warfield is talking about is the name of an attorney or attorneys who advised me, and that I do not believe states a complaint under the Sunshine Ordinance. That is the question that he has posed. Thank you.
Thank you. Is there anybody here to present facts and evidence on jurisdiction in support of the respondent? Seeing none, there's already been a motion. Is there public comment on jurisdiction only?
I think sunshine covers advice that's given by an attorney to a city agency or a department, but it doesn't say you can't tell who the person was. And I don't see in any way disclosing the name of the attorney, whether it was your in-house or in-department attorney or whether it was somebody in the city's attorney's office. Would it compromise in any way the discussion that you would have with that person?
Thank you. Is there further public comment? Okay. At this time, we will invite the respondent and then the complainant to issue any concluding or rebutting remarks on the matter of jurisdiction. Ms. Goldstein, you have 3 minutes.
Just again, very briefly, I understand that the Sunshine Ordinance does require disclosure of some information, specifically written information that is provided by an attorney to a department that has to do with the Sunshine Ordinance itself. But that is not the subject of this complaint. The subject of this complaint is simply the name of the attorney who provided, or attorney or attorneys who may have provided advice to me. And that I don't believe is disclosable. I think that is privileged and confidential information. Thank you.
Thank you. Mr. Warfield?
Yes, thank you. First of all, I think that the violation included not just a refusal to say who was involved in providing legal advice, although that isn't quite as simple a question as it might seem. The Board of Appeals has its own attorney on its own staff. I believe it's called in the organization chart a legal assistant. But I was given to understand on my multiple visits to the office that this was a full-fledged lawyer. So at the time that I asked Ms. Goldstein in the discussion of these new rules, and I was given to understand that an attorney had been consulted, I did not know whether this was the staff attorney. In other words, I didn't even know what office had been consulted. So I didn't know whether it was the city attorney, whether it was the staff attorney on their staff, or perhaps somebody else. In any event, I think Sunshine is very clear that attorney-client privilege does not apply to anything having to do with advice on Sunshine. The section that I would cite is 67.21I, which says, the San Francisco City Attorney's Office shall act to protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public record for purposes of denying access to the public. The city attorney may publish legal opinions in response to a request from any person as to whether record or information is public. Sorry. The last sentence, I think, is very clear. All communications with the city attorney's office with regard to this ordinance, including petitions, requests for opinion, and opinions, shall be public records. Now, I think this one is pretty clear. I also think that oral information is something that we haven't heard much about at the Sunshine Ordinance Task Force, but I think that it's very important and very valuable and very clear. You routinely go and ask somebody in an office, excuse me, when is the meeting of the Sunshine Task Force today? Or what time does, where is it located? I think Member Craven said I can't think of the question she had, but we routinely in all of our doings are asking for and receiving and sometimes giving oral information. It's the routine way that most information is provided. The state law does not, the Public Records Act does not mention, is that 5 minutes?
3. On rebuttal, you have 3.
Okay, so Section 67, 20, 21, and 22 clearly talk about oral information separately from documents. So there's, in various forms, public records, such as 6720B, public information and its definitions.
Please conclude your remarks.
It's clear that oral information is a separate category but subject to disclosure in Sunshine.
Thank you. The matter is back with the committee. There is a motion on the floor and a second to find jurisdiction. Is there further discussion? Roll call, please.
On jurisdiction, Member Craven excused.
Craven Green is excused.
Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Aye. Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Mr. Chair, we have 7 ayes.
Okay, we are now ready to proceed on the merits. Mr. Warfield, please approach. Again, thank you for bearing with us. You have 5 minutes.
Thank you, Mr. Chair. The story continues. When I heard from the staff that the Board of Appeals had changed the rules quite suddenly after apparently a run of forever that anybody could remember, including people who'd been there many, many years, I was kind of startled and surprised, and especially when I heard that this happened apparently not even half a workday after my first appearance there late the previous week. So I asked for Ms. Goldstein to give me a call, since evidently she was the one who called the staff meeting and gave the instructions. Without going into the details of what I had been told by the staff and so on and so forth, I did, in bare bones outline, understand that no longer was I able to freely make notes and inspect documents, as I had the previous week. No longer was I to be given copies of documents that had information about who wrote them. But instead, I think you've heard the rules more or less orally described, although I still don't know anything written exists. But I did want to talk to the director about what had happened. So she very promptly and kindly called me back the next day, and we spoke briefly about what had happened. I was unable to ascertain what had prompted the change of rules, and that certainly concerned me, because all of these issues with the library are highly, highly political and very hot in certain respects. I could not understand what had prompted the change of rules, but she did let me know that she had consulted an attorney. Since I had an awareness that they had on staff an attorney, and also there is the city attorney, or who knows, maybe they hired an attorney, I asked what attorney, or who was the attorney, and by that I certainly meant what office as well as who. And her answer was, that's irrelevant. Now, in my letter, I said it was said in a rather frosty tone, that in one of my letters that didn't suggest there were further questions going to be welcomed. This was not to suggest that a frosty tone is illegal. It was simply to fill out the story as well as explain why I might not have asked a lot of follow-up questions. I didn't ask a lot of follow-up questions because I was already not making progress on what had happened. And when I heard that's irrelevant, that was a signal to me that further questions and further discussions were not welcome. I have said that oral information is mentioned in Sunshine at various points, 67, 20, 21, and 22. Section 6722 in particular says, Section A, every department head shall designate a person or persons knowledgeable about the affairs of the department to provide information, including oral information, to the public about the department's operations, plans, policies, and positions. Certainly, I think that sudden change of policy on 67.22a, first sentence. Certainly, I think that it is a reasonable query into a department's policies to ask what has prompted this change after so long, a contrary practice, and also to ask where did the advice come from, particularly since Sunshine says that city attorney and Sunshine communications are not subject to attorney-client privilege. Certainly, I don't think that the name of the city attorney, even if it was, would be subject to attorney-client privilege. It's like with a doctor. You may say, well, my doctor is so-and-so, but you and the doctor may not say anything that's confidential about your medical history or medical conditions and so on. So likewise, I could have been told, well, I talked with so-and-so, but everything that I discussed with him, in my opinion, is confidential. As I said, we routinely obtain oral information. It's not necessarily related to documents, although it may be when you ask, what was the vote on last night's Sunshine Ordinance Task Force meeting on item such and such? There may not exist a document, but if you're asking somebody who was there, like the administrator, you might be able to get a straight answer about, oh yeah, that vote was such and such, or even if it wasn't from memory. In this case, the information was in the memory, very clear and very recent for Ms. Goldstein, and there was not a question of creating any documents or of having to look up any documents or of having to synthesize any documents. She herself had been the agent and knew everything about my questions and could have and should have answered. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, Ms. Goldstein?
Thank you. Again, Cynthia Goldstein for the Board of Appeals. First of all, just to be clear, there are no attorneys on staff at the Board of Appeals in that capacity. There are people who are attorneys who work at the Board of Appeals, but we do not have a staff attorney position in our office. The information that Mr. Warfield just went over regarding the reason for the change in policy was the subject matter of the prior complaint that was just heard and decided. This complaint is simply about whether or not it is required that my office disclose to him the name of the attorney who provided my office with advice. I believe that information is privileged and confidential under state law. I don't think that he is entitled to that information. I understand that the Sunshine Ordinance requires departments to disclose certain written advice from a council regarding public record requests, but I don't believe that oral advice needs to be disclosed, and in particular with respect to oral public information as defined in Section 6722 that has to do with operations plans, policies, and procedures, as Mr. Warfield stated. I don't believe that the name of an individual attorney providing advice has bearing on the operations plans, policies, and positions. If he had wanted that information and had asked me for that information in a way that I understood that was what he was wanting, we would have certainly provided it to him. We had been trying our best to provide Mr. Warfield with all of the different pieces of information that he'd been asking for as quickly as possible, not taking the time that is allotted to us under the Sunshine Ordinance, but simply trying to be as prompt and as effective in assisting him and his requests. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Johnson and then Member Knebber.
I just have a simple question. As a member of a policy body, a public body, and if I was to ask our city, Mr. Lente, a legal question, advice, and someone was to come to me, would I not be required orally to say who it was?
Mr. Laurenti, would you comment, please?
Well, it's a little different with the Sunshine Task Force because there's nothing that I provide that is confidential. It is very clear that what I provide is public information, and in any communication I have with any of the members here, I let them know that none of what you tell me or what I disclose is confidential. So it's a little different situation. There are situations where an attorney advising a department may provide confidential information. The question is, does that information, is it in response to a complaint involving a sunshine violation? If it's an opinion regarding a sunshine violation, then that opinion is not confidential. It's disclosable. I mean, the record is very clear that any communications between the deputy city attorney and the department regarding sunshine or Public Records Act or public meeting laws is public record. And so, I mean, this is a little different twist because it really, it was about a change in policy, and the question is whether or not there should have been disclosure of the attorney who might have been involved in the change of policy. But was it actually in response to a complaint at that point in time? It's a little early, I think.
Does attorney-client privilege cover the name of the lawyer or law firm?
Well, usually if he wrote something, then definitely not, because his name would be disclosed in the opinion. I mean, this is a little different because it's dealing with oral information. Had there been some communication in writing that had been provided, then that had to be disclosed, and of course the name of the attorney would have been provided. But that was in a situation where there's something written.
Member Knebber.
Yeah, that's where I'm at right now. I don't think that this is. I mean, I don't understand why it's a big deal, but I don't think that this comes under us as a violation when it's the name, finding the name of the attorney. If, as Mr. Laurenti said, there was a written brief provided, if it was her asking advice because she had to respond to the Sunshine Task Force about something, I think that would be different. But as is, I would vote for no violation of that movement if somebody moved that.
Okay. Member Washburn?
I'm confused about why written communication, if you were, the name of the attorney would of course be there. And why isn't it a similar situation with oral communication?
Well,
I mean, it isn't, you have to be told who you can't read who the lawyer was. You have to be told that, but I don't see any real difference between the two.
Mr. Lundy?
Yeah. I think what it is communication between an attorney and the client agency in response to a Sunshine or State Public Records Act or public meeting law complaint or issue, that is subject to public disclosure. Okay.
Mm-hmm.
Let's suppose that there was this complaint and the director called for advice on how to handle it. Or if this was a situation where there was a request for a public record and the director wasn't sure whether some part of that information was privileged or not and called an attorney to get that advice. Well, that advice would be public record. Here, we're dealing with a situation where there was a change in policy and an attorney might have been involved in assisting and providing information that caused the director to change that policy. That wasn't a subject of a sunshine issue at that point in time. It hadn't yet come to that point. And so the question is, as it deals with oral information about policy, changes in policy, there's a question whether or not the disclosure of that attorney really falls within the right of disclosure. That's what I'm basically saying. It's a fine line, but I don't think that it does.
Member Washburn?
But if this change in policy is about sunshine, a policy that affects sunshine, I would think it would be disclosable, the attorney giving the advice. We're talking about, it's related to a sunshine request, and it's regarding how these requests should be handled. So I kind of see it, as being very similar.
Member Williams?
I'm on the same line that you are.
Speak into the microphone,
we
please.
have city attorneys that come up here and we see their faces. I mean, we just had one that came up and, and it's no secret. I mean, unless they were given erroneous or information that they don't want out, I don't see any harm in knowing who the attorney was. I mean, it's not a criminal case. We just want to know, I don't see the difference. I really don't. And I don't see.
Member Knibber?
I don't see what the problem is, but if I'm looking at the way it's written and the way that I read it, we have to deal with public records or advice about sunshine. Now, we can interpret this as a response to change in policy regarding sunshine, but that's not strictly how it's stated. So from I think it's a line, as Mr. Lawrence said, but from what I've seen and what I hear, I just can't see it as a violation. I would need more information.
Member Johnson, did you have a comment? And then Mr. Goldman.
I see that he made a request for information, and then later on he was denied that. That's a sunshine request. He made it under sunshine, and then later on was told that he can't have it because of because the policy has changed because of advice given by a lawyer. That's the way I'm interpreting it. So that's why I'm interpreting it as it does fall under sunshine.
Member Goldman?
Well, I voted for jurisdiction because I do feel we have jurisdiction over this item. However, I feel that Ms. Goldstein was well within her rights by not answering that question, and I would move that we find no violation in this matter.
Is there a second?
I second.
Okay, moved and seconded. This time we will take public comment.
I'm kind of confused about this because basically what we're talking about is access to public documents and a policy change that resulted in access being denied. And that access was claimed based on advice of an attorney. So basically what has been said is I went to an attorney, the attorney told me I could do these things. Well, as Ms. Goldstein mentioned, in the prior case you already ruled that part of that information was incorrect because apparently during this same conversation this attorney said you can redact this information, and that was incorrect. So the question then becomes, well, who? I mean, who was this attorney? Was it the city attorney's office? Is it somebody I needed to pass by them or what? So without that information, you really don't know. And I'll be very honest with you, and I'm not saying this has happened, but I think all of us at one time in our life have been involved with somebody who just basically said to you, I talked to a lawyer, and you sat there and said, well, given what you're saying to me, I kind of find it hard to believe that you did talk to a lawyer. And so I think there is a valid question here as to whether or not someone did, and if someone did, and to some degree we've already determined they gave her erroneous information, well, then that attorney needs to be consulted, and the only way to do that is to know who the person was.
Thank you. The chair will note that there is nobody else in the public gallery, so public comment is closed. The matter is back with the committee. Is there further discussion? I have something I'd like to say. First of all, if you look at the language in the relevant section, 67.24 B1 Roman 3, there is no mention here of the word written or oral. There is no distinction in the requirement of whether, in the disclosure requirement for between written and oral. It does not say written advice on compliance. It just says advice on compliance. That's the first point. Second point, I'd like to recall what Mr. Laurenti said. If the advice had been written, the name of the attorney providing the advice would be disclosable. The fact that it is oral advice, to me, again, does not call for a distinction. It was advice given on a matter regarding sunshine. Therefore, as far as I'm concerned, the name of the attorney or attorneys is disclosable. Third, Ms. Goldstein points to, in her written memorandum here, she points to state law, Evidence Code, Section 950 at SEEK and sequential. See also Good Government Guide, an overview of the laws governing the conduct of public officials. The California Public Records Act and the Brown Act expressly give cities and counties and local jurisdictions the power to adopt sunshine laws that call for broader disclosure, more disclosure than the state laws provide for. We have the right to say, notwithstanding such and such exemption in the California Public Records Act or such and such exemption in the Ralph M. Brown Act, this meeting shall be open, this record shall be disclosable. And I think this ordinance, specifically under 6724 B1 Roman 3, I think this accomplishes that. Therefore, I will vote against the motion to find no violation. Further public comment. Roll call, please. Again, this is a motion to find no violation.
On the motion, Member Craven Green. Member Craven Green, excuse. Member Nee.
No.
Member Nee, no. Member Cawthon.
No.
Member Cawthon, no. Member Washburn.
No.
Member Washburn, no. Member Knebber.
Yes.
Member Knebber, yes. Member Johnson.
No.
Member Johnson, no. Member Chan. Member Chan, excuse. Member Goldman.
Yes.
Member Goldman, yes. Member Williams. Yes. Member Williams, yes. Member Chu. Member Chu, excuse. Mr. Chair, we have 3 ayes and 4 noes.
Okay.
I believe we have 2 and 5. No violation?
3. Marjorie Williams voted yes.
Okay. Well, the motion fails, and I am firmly convinced that if somebody presented a motion to find violation, it also would fail. Does anybody want to make a motion to find violation of 6724B13 or any other provision in the ordinance?
I so move that we find violation. I don't have the numbers of the
67.24B1 Roman numeral 3.
right.
I'll second that.
Moved and seconded. Discussion? Roll call, please.
On the motion, Member Craven Green. Member Craven Green excused. Member Cawthon?
Aye.
Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
No.
Member Knebber, no. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan excused. Member Goldman?
No.
Member Goldman, no. Member Williams? Member Williams, aye. Member Chu? Member Chu excused. Member Nee?
Aye.
Member Nee, aye. Mr. Chair, we have 5 ayes and 2 noes.
The motion fails. At this point, there is no further action to be taken on this item. Thank both sides for attending and again for bearing with us. We know it's been a long evening. We appreciate your patience. Mr. Clerk, would you read the next item, please?
The next item is the use of vendors or third parties to respond to public record requests. Mr. Chair, I sent Brian Smith. This is the second time I've sent him an email. He hasn't responded.
Okay. This is item 25, is it?
25, yes.
Okay.
Through the chair, he did make a presentation at the EOTC meeting.
Okay. Well, perhaps then, during the EOTC report, in a few minutes, Member Cawthon can refresh us. But if the presenter is not here, then I would say we can withdraw the item. He can bring it back if he wishes, and let's move forward to item number 26.
I just have a question.
Member Cawthon?
Did Brian Smith ever come to the EOTC meeting? Because it was originally an EOTC item, and then we, for some reason, decided to send it up to the task force. Did Brian Smith ever come to the EOTC meeting? I think someone did originally.
Come to the meeting.
To
yes.
the EOTC meeting, yeah. So maybe we can send it back and write in one of our. We'd be honored if you'd come and talk to us. Is that okay? That might be. And if that doesn't work, then we can forget it. But I never was quite clear what this was all about. But there was somebody there from the planning department who. I'm not sure if Brian Smith was the person or it was somebody else, but I mean, I would be willing to give it one more crack at the EOTC. Is that what you were talking about?
Well, no, I was going to say that if you wish to, Mr. Rustum said that Mr. Smith appeared before the EOTC. Is that correct?
That is correct, Mr.
At the
Chair.
last meeting?
No, meeting before last.
Oh.
2 meetings ago.
Okay. Well, what I would say then is let's withdraw this from the agenda, and if Mr. Smith wants to reschedule, we can put it back on for next month or whenever, whenever he wants to reschedule it.
Okay, Mr. Chair.
I hate to do
Member
this
Cawthon?
at this late hour, but I know somebody was there and we had something about this, but I never was quite clear what he wanted. Were you?
I think we would have a
You can't tell from the agenda item.
Maybe we should move along.
Well, I think if we can spend 20 minutes talking about whether or not an oral public request for the name of an attorney is under the Sunshine Ordinance, I can get an answer to this one question. I mean, we're all tired. We all want to go home.
Member Cawthon, presumably you were there, and if what I would suggest is that you go over the minutes of the August EOTC meeting, or listen to the tape, or both. That might help clarify it for you. I mean, none of us was there. I don't think perhaps Mr. Rustum, Mr. Laurenti can give some kind of recollection.
I would have to revisit the notes.
Okay, so perhaps a review of minutes and or tapes of that meeting would be helpful in that regard.
Look, I'd like to let it go. It's late.
Okay.
I want to go home.
Could you call the next item, please?
Item number 26 is approval of Know Your Rights brochure.
Okay.
I think the brochure looks great, but when you fold it and then you open it, it's upside down on the inside. So.
Well, the one that we have that I'm holding here in my hand opens the right way. It was just
I
the way
think this is
was
a great
copied.
improvement over what you had before.
Thank you.
Okay.
Yeah, what we did was we just, there were some comments last time, like we had to straighten out the bullets on page 1. We put a few words in. We decided to put in some of the code sections. We tweaked the language a little bit. This is our, this is draft 8. So I move that we accept this, and this is our official document.
I second that.
Moved and seconded. Is there any public discussion on this item? Seeing none, public comment is closed. Is there further discussion by the task force?
Yes, Chairney. I would just like to point out one thing about the brochure, is that this one, I believe, is in English only, not like the previous available in English only. So perhaps when we get our new member from New Media, we need to search out to translate it to different areas, such as like Chinese, Mandarin, or Spanish.
Well, perhaps we don't need to wait for the, it's we don't know really when our new member will join us.
I just wanted to make that clear.
But maybe we shouldn't wait. Maybe we should begin undertaking that effort as soon as possible. Mr. Rustum, do you know of any translation services available to the city that we might be able to use? Or does perhaps I would assume that the Board of Supervisors in their literature and other city agencies in their literature make translations available. Could we ask? It would be imposing if we ask you to investigate what's out there, what's available.
I can double check and get back to you on it.
Okay, perhaps you can report at the next meeting.
We'll do that, sir.
Okay, thank you very much, Mr. Mr. Johnson. That was an excellent suggestion. Thank you for it. Okay. I don't think we voted. It's been moved and seconded to accept this and to print it for distribution. Is there further discussion? Roll call, please.
On the motion, Member Craven Green excused. Member Cawthon.
Member Cawthon is excused.
Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu excused. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 6 ayes.
Thank you. Next item, please.
The next item is a report by the Complaint Committee meeting of August 11, 2009.
Our last complaint committee was a short one. We did not have a lot of business to discuss. The document you have in front of you is an accurate reflection of that meeting. That concludes my report.
Okay, any questions? The chair will note that the public audience gallery is empty. And I believe that takes us to the next item.
Next item is a report by the Compliance and Amendments Committee meeting of August 11, 2009.
Okay. Chair Craven Green has had to leave, so I will just say that the minutes here are accurate and thorough. Just want to call attention to a couple of things. On the electronic email retention policy, still a work in progress. I was invited to attend a meeting last week of the Committee on Information Technology, and that meeting was canceled, and the next one is scheduled for next month, so I intend to go to it. Also, the amendments, the drafting of the amendments to the ordinance remain a work in progress. At this point, I would invite other members of the Compliance and Amendments Committee to make any additions, corrections, deletions that they believe are appropriate. Member Washburn, Member Johnson? Okay, that concludes the report.
Item number 29 is the report from the Education Outreach and Training Committee meeting of August 13, 2009.
Okay, Chair Coffin has had to depart. Member Williams, Member Johnson, anything you care to, any comment you care to make on the report?
I would just say that everything is accurate that we have.
Okay.
And I'm really glad it was miscommunication about me being here. But the workforce development is really a good one. We should get that.
Okay, thank you. Next item, please.
Next item is the administrator's report. Mr. Chair, I do not have anything to add to what I have in the packet.
Okay, are there any questions on the administrator's report? Seeing none, that would take us, I believe, to the final item, which is announcements.
Comments.
Okay, any announcements from the task force?
I just have one question. If we know the status of when we're filling the seat from New Media.
Mr. Rustin?
The application is going before the Board of Supervisors Rules Committee meeting next month.
Next month?
Next month.
Okay, do you have a specific date on that?
I believe it's on the September 9th.
Okay. Member, speak into the microphone, please.
I'm so sorry. I didn't know Mr. Frank Darby had left, and I think we should send him something, certificate or whatever, because he was good when he was here. So I think he just left, unexpectedly.
I believe he found work in the private sector.
Pardon me?
I believe he found
know.
work in the private sector.
I talked to Angela after I called.
Okay.
He was calling me every day, but all at once he didn't call anymore, and then he wasn't here anymore. So, but I think we should get a certificate or something to thank him or something.
Or send him a card.
A card.
A thank you card.
Mhm.
Okay.
Well, you're saying a thank you card, and this lady was only here for 2 or 3 months, and she's going to get a certificate or something. So why should he get a card? He get a certificate like everybody else. I don't think he should be treated any different.
Speaking of which, I think we have to do something for our DCA as well.
Yes, I was going to get to that. Mr. Laurenti is going to be retiring, and I believe this is his final meeting with the task force. Mr. Laurenti has...
I have put a request in that after my retirement goes into effect in October that I be considered to work part-time to do this. My boss has gotten word to me that he doesn't have any money for a requisition position right now, but he'll think about it during the course of the year, maybe later in the year or beginning of next year. So, but in the meantime, there will be a substitute.
Of course,
yeah.
So this is your last meeting? I thought
Yes.
next meeting was...
No, I'll be out.
Well, can we call you back?
Oh
for a-
yeah, I mean,
an
I
award or something.
Sure, you could call me back I'll be pretty much clear, so you could call me back. Right, let's all meet at that bar over on.
Do they have good beaches in Alaska?
There's some great glaciers before they melt. I'll see you in Seward. It's a great place.
There you go.
Like judo myself.
Well, Mr. Laurenti, we want to thank you for 9 years, I believe you've been doing this, and I
8
know
years
that
plus, yeah.
I know that there have been times when we haven't always seen eye to eye on things, but one thing I will note is that the diligence with which you've approached the job. At times we've had very voluminous agendas and with numerous complaints that would dwarf this one of tonight, and the research you had to do in looking up the applicable laws, statutory and case laws, must have at times kept you up quite late at night, and I think I can speak for all of us when I say we deeply appreciate what you've done for us.
Well, Mr. Laurenti, personally for me, I want to thank you for your spirituality that maybe the other members don't know. But every time something happened to me, you always had a hug for me and had a kind word for me to keep me uplifted, to go further. So I really thank you for that. and I'm going to miss you. I mean, we've been together a long time, so.
Like an old
it's
married
like
couple.
I'm about to break down now. I'm glad you told me I did.
Well, I'll come back for
I
some.
can't say goodbye. Oh, we've been together so long. So hard to say goodbye.
It's been a pleasure. It's been a pleasure, really.
This meeting is adjourned.
Okay. All right.
Thanks for the water. I appreciate it.